Yes.
This transportation was filed on 14th of August, my lord. It was numbered on 17th, my lord. But it has not come yet.
We'll have to make the mention before the senior bench.
Senior bench.
For listing senior bench except bail up to 7 years.
Bail ने की जगह.
Not with transfer petition.
Transfer petition.
Transfer.
May I please, Your Lordship?
Yes.
I beg to mention item number 33. My senior is not in station. But let the matter come on Friday.
Is PD available, my lord?
Let it be on Friday.
Is on interim.
Lordship.
Any interim?
Lordship.
Interim is there, my lord. Yes. On 25th. 25th.
It is Friday.
Friday. Friday.
On the prayer of the learned council for the
May it please, Your Lordship, with due consent of the other side, I beg to mention item number 57 of the daily. I mean, this matter may be adjourned for a week, Your Lordship.
Hearing. Hearing.
you are for
I am for the respondent, Your Lordship. S.A. Borbuin.
I mean,
any interim order?
Lordship, yes, there is the entry order.
Okay, if you respondent, there is an interim order. Okay, on the prayer of the for this matter.
Yes, Lordship. There is no interim, Lordship. I apologize, Lordship. There is no interim.
No. This matter will not adjourn. We do not require your assistance. Whether the amount was transferred to the account of the, I think this is the case. That's why we have to show the name of NJ Khatania.
Lordship. Then highly
Yeah.
obliged.
Yes. We will not adjourn it.
Lordship, I beg to mention item number 12, my lord. My lord, matter will be fixed on Friday, my lord. The senior is out of station, my lord. No, it has come for the first time.
Motion.
Maintenance will only issue notice.
My lord,
Your senior's presence is not required. Yes, next year.
Lordship, I beg to mention an bail application, regular bail application, Lordship, for motion tomorrow, Your Lordship, if possible.
Under section
370, Your Lordship.
370.
317.
370.
370.
Yes, tomorrow.
Deeply obliged.
I beg to mention item number 15, Lordship, motion matter.
Yes.
May come up Thursday, Lordship, because the learned engagement is out of station, Lordship. SAB could be related.
So what is this? Will issue a notice 127.
Yes.
Twice rejected. Will issue a notice.
Okay.
Nothing more. Why you require it? Yes.
may I please, Your Lordship?
We are not dismissing it. Yes.
Lordship, I beg to mention item number 32.
30?
32. 32. The case there is not available.
33?
32.
2.
We are on interim law.
It's from Azara, my lord, these are interim.
Hmm.
September 14, my lord.
14 September, interim to continue. Item 32.
32, my lord. Lot of that.
Ma'am, please, Your
Yes. Wish for the
You are Lord. Yes, Lord.
two brothers fighting for money.
Yes, Lord.
City interim.
Yes.
When?
Dulyajan, no?
Yes.
Dulyajan, my lord. 12 of September.
Yes, 12. Within 10 days.
Lordship.
Yes.
Let's read along. FR page 11, my lord.
Yes, what do you say? Sorry, something
Sickness are brought.
signature. It's believable. If you have done out of love everything, let it be yes, city interim. You were dead. Record your statement.
Khanpati.
No, it is September last. 21st of September.
21st of
Yes, Upadhyay. Who is the owner of the fertilizer?
Yes, he is the owner of the, but the thing is that,
Who is the owner of the fertilizer? You are the owner of the truck.
truck, yes. I am the
Now,
owner
what
of
is
the
your
truck, it's not the
explanation?
purchase. I have got the original also.
Original what?
Yes, Chalan. Original Chalan of the fertilizer.
So, who is the owner of the fertilizer? You are.
No, I am the owner.
Huh?
I am the owner. It is a.
You are
in
owner of the vehicle as well as owner of the
It
fertilizer.
was a duly purchased.
But it says this is meant for not from open market. It is
No, no.
meant for
It is open market. I have an that circular. Lordship, your lordship will see the circular.
where is the GST?
No, GST to he paid. He paid.
Where is the GST number payment in the bill? We do not believe in this kind of bill
Well,
nowadays.
even that, suppose there is no such thing. But
If
whether
no such thing, government subsidized fertilizer meant for poor farmers, if are sold in open market, we are not granting any.
no, here your lordship will keep it annexure 2. Annexure 2. You know the urea, it is not a urea. So except urea, other are
Annexure
annexure 2, page number 12.
DAP.
Yes. The last hence for smooth distribution of throughout the state.
Annexure 2 page.
To page 12. Third paragraph. Hence for smooth distribution of throughout the state DPF, DAP, mine is the DAP, are exempted from the inter-district movement restriction. Except urea. Urea is not allowed.
Oh, if urea is allowed, but DAP is not allowed.
No, no. Except are exempted from the.
No, that we understand.
Yes.
There is
There's
no
no
problem
restriction
on
at
that.
all. There is no
You
restriction.
buying from someone traveling, there is no issue. But the report says that these are the.
The report, even then,
it's
whether
meant,
it is a
it's
case of
meant for,
whether, yes,
it's
Lord,
meant
I
for the
have nothing to-
subsidized thing.
Yeah, I have,
And we thought that
But
you are
whether-
only the owner of the
exactly.
vehicle. Now you come and say that I am owner of the fertilizer also. And with a
No,
receipt,
right now, it will be delivered at Boko. There is a name of that person.
we understand, but there is nothing.
Yeah, but,
We cannot believe this.
my lord,
You cannot sell like or
no,
purchase.
I am not selling. I have purchased from that.
You cannot purchase like this.
No, even then, it does not amount to the theft. How it is? Suppose
That
I have violated the certain provision of purchasing. The manner in which
No, no,
ought to have been
that is
purchased,
not
I have
the
not
issue.
purchased.
Issue is that we doubt this
No,
purchase.
doubt is that a different type of doubt. Yes, lords, I agree with your lordship. There may be a doubt, but whether that doubt amount to the
And
committing of theft,
and how you answer this, the forwarding report of the other,
for what it?
where is that?
I am not a name accused. I am not a name accused.
You need not be named because you are coming and saying that this belongs to me. Why you should be named? You are naming yourself.
No.
Isn't it?
Your lordship will see why I have come. Your lordship will see paragraph 5, page number 5, 16, annexure. Otherwise, I was not apprehending any arrest earlier. I visited the PS. Nobody questioned me. Because I applied for the Zimma of the vehicle and the goods, then this. They said that I am absconding. How I can be absconding, your lordship? I am the owner of the vehicle. Yes, sir. surprised. Only because they said I am also accused. No notice, nothing. If I am the accused, the notice ought to have come to me.
Then notice you will have to allowed to be go.
It is
Then yes,
mandatory
yes, you
now.
go. You have bought stolen property. We will have to give you
No,
notice. So you
no, no,
better
it's not
go
how
home.
it
We are
is.
sending you the notice.
Lordship, how it can be a stolen property? Suppose I have no document, but I have shown from where I collected it. I have clearly shown from where I collected. The meaning of the stolen property would be then different. And what
What you say?
What city will reveal?
the city in the interim, my lord, interim protection, my
Yes,
lord.
Daddy. Give
My lord.
early date.
My lord, interim, I
September 8th, Lord.
otherwise there is not that, my lord.
8th of September.
8th of September.
This is from which place? Jalukbari.
Jalukbari.
We give up earlier date, not 8th September.
Earlier day. No, but
On 31st of August.
31st.
31st of August.
31st. You take it.
Yes.
No, 31st. Yes.
430 application, my lord.
City scholarship.
Bhoyapuri police station.
Actual fact was something different, my lord, but then that only CD will reveal. I will kindly fix a short date. That's okay.
September 8th, Lord. Bhoyapuri police station.
First, my lord, if possible, because CD will reveal
You
my
have a date from PP. I cannot say that. That will depend upon their. I have no problem.
September. September 1st.
deeply
September
oppressed.
Yes.
438 application in connection warrant here. FIR is case number 17 euro.
14,20,000.
Yes, sir. But I have received only 20,000 which I have annexed in annexure 2 euro. Because
What about supplying the material?
75 labors are working in that place is zero. In case number 6 of my petition, I have stated. Thereafter, the husband of the informant
Hmm.
tried to sexually assault the female laborers of the labor camp, and thereafter they he stopped.
City interim. When? Nazira or something like that.
Moran police station. September 8th.
September, you appear within 10 days. Then what to pay?
I'm not naming the FIR. My manager was arrested, my lord. But nothing was recovered from him. He was already granted bail, my lord.
What was the allegation?
Illegal, there was a CCTV footage was there, my lord. That is on page 8, my lord. And they made some thieves enter into his house, my lord. Broken the window and some useful things were stolen.
Interim. Please, city interim. When?
On 27th of September.
27. Appear, huh?
Yes,
April.
27.
Yes.
This is a petition under section 438 of the This is FIR is a case not 11.
Serious allegation.
And the sixth number of the accused my lord. Already, my lord, the accused number 4, my lord, he has got the bail, my lord, from this round of court, my lord, which is the case, my lord, 25.
Brother-in-law.
No, my lord, other co-accused.
Who are you?
I am totally.
You are a
I am the
husband or
only son of the
brother-in-law?
accused number 1, my lord.
You are husband or brother-in-law? Husband.
No, my lord.
Brother-in-law.
No.
Who are you then?
I am the villager of the accused number 1, my lord.
What is the allegation against you?
Actually, my lord, there is no allegation against me, my lord. And the name accused, my lord.
Then why are you apprehending?
Yes, my lord. My name is
Specific allegation against 2 persons. What is the role of villager? Why are you apprehending?
I am the accused number 6, my lord. And the name accused, my lord. There is a dispute, my lord,
Page
between
12,
the,
number
between
6.
the
Rohit.
enforcement as his wife, my lord, which is accused number 1, my lord.
Where accused number 6?
Accused number 6, my lord, Rashidul Haq.
Page
Well,
12.
Page?
Page
12.
12, my lord. My lord, the accused number 1, my lord, Zinnatun Bibi. He has closed an FIR, my lord, and her case has been registered under section 376, my lord. Just 2 days later, this FIR has been lodged by the enforcement. I am neither the husband nor the relatives of the accused number 1. This FIR has been lodged, my lord, just counter lodged.
Oh, similar cases are somewhere taking money
Oh, yes,
for
sir.
bribe to
On the
bribe the
pretext of,
police.
yes,
Yes,
yes. And my lord, here accused number 1 is the, my lord, wife of the informant.
Informant.
And
Ah.
my lord, my lord, all the accused person conspired, my lord, with my lord accused number 1. So 120B is there, my lord. So my lord, day after day, my lord, on the pretext of my lord compromising the matter, my lord.
Twice they have taken money.
Yes, my lord.
I think some others we have not granted interim bail and
Yes, my lord, at page 25, my lord.
Huh?
Page 25, my lord. It has been date of 29/8/2023. Interim of the appellate. Yes, my
Okay,
lord.
because
Idris Ali, my lord.
Huh?
Idris Ali is accused
only
number-
because one
eh,
Idris
eh,
Ali is
Idris
granted
number-
bail, that is not a ground for my lord regarding how they are involved.
who is he, Idris Ali, how he
Idris Ali, my lord, accused number 4, my lord. In fact, my lord, this affair has been lost, my lord, just
other has been granted without
Yes,
any
yes,
interim. When?
on my lord 29 my lord,
20 September.
September.
intimate. Obliged.
CD. This is
420.
Pankaj Bayan.
Yes, Pankaj Bhai.
Okay, CD interim.
My case, my lord, intimate.
On 22/9.
Obliged.
22/9. CD.
Sir, Lordship, if I'm saying, Lordship, case 28, I admitted that before filing FIR of 1 month, I admitted and paid the money, Lordship.
Maybe.
Yes, Lordship.
Maybe.
Second, in the FIR,
People like you are not
No.
entitled for privilege.
yes, Lordship, I'm
We'll
saying.
collect money from
No,
the
Lordship, Lordship,
uh,
I am not collecting.
poor people and
Yes,
will not deposit.
Yes,
You
I am,
take receipt.
no,
And there
I
is
am,
specific allegation. my lord.
Specific.
before filing FIR 1 month before, I deposited the money, Lordship.
Maybe.
Then in FIR
Maybe.
also, small amount is
That
remaining.
cannot be a ground to
Yes,
grant you
Lordship.
anticipation.
On 12/9 my lord.
12.
Only this only.
Case for reject.
Yes, sir. Just one notice has been served up to me, page 18, Lordship. I am told by actually, I ought to appear, Lordship, on 11, Lordship. On that day, I could not, Lordship. Page 18, Lordship.
This case, sorry, if
Yes.
you want, I can pass a
Yes, yes,
detailed order
Yes.
why I should reject this bail without issuing an order.
Yes.
Option is given.
Yes.
Yes.
My lord,
Chaudhary.
respect, my lord.
Mahajan.
FIR is at page 12, my lord. It is apparent, my lord. His friend has taken away the vehicle, but he has not named him, my lord. Page 12, my lord.
Seen that.
And I am, my lord, on the date of occurrence, I am appearing in examination. What I did, my lord, Lordship can leave here. 41 is
Notice interim.
highly obliged.
On my lord 27 my lord.
My lord.
And appear to the Onet Thompson. Name of the council for the petitioner is not for. Accordingly, registry to release this letter on 25th, showing the name of the learned council petitioner. Art, the learned council for the parties. Christian application. Yes,
My lord, there is an interim
what kind of interim one?
Well, there are two petitions. There are two petitions. One is the titleship, and another we are against the maintenance order, my lord. My lord, may kindly turn to page number 8, my lord. My lord, on the ground floor.
What was the amount?
My lord, 4,000 for the respondent and for 4,000 for the wife.
Yes.
Sorry, the girl child for the respondent, my lord.
Yes. Then
My lord, point number 4, my lord.
what do you do?
My lord, I'm a vegetable vendor, my lord. My lord,
Notice on interim. State within 5 days. We have not granted any interim. Notice on interim. Returnable. Same notice.
Alright.
Notice on interim.
Alright.
Yes, Mr. Kotoki.
Yeah, please, Your Lordship. This is regarding a DIPA of some seized articles, man. These are
Yes, about Kotakur.
Yes, my lord.
Suppose these are, there is a direction to confiscate.
that cannot, that power is not
That
with it.
cannot be. Police has not started any process. It is the concern of the magistrate. This is explosive. If it is explosive, that can be given to the custody of any other, maybe IOC. Have a
Yes.
report. Till then, interim.
But here in this case, here page 43, my lord.
Yes.
No, 14, huh?
43.
14, no. My lord, here, second paragraph, my lord. As the case falls under the ambit of Essential Commodities Act,
Ah.
so hence the matter of seizure and confiscation of the seizure is to be duly under relevant provision of law.
Ah.
So, my lord, any
What-
application
What the essential commodities say?
so appropriate.
Can there be a direction confiscation?
Yes, no, my lord. It is deputy commissioner.
Deputy
have to
commissioner.
decide.
Then to
The
So
IO has
there-
to make a prayer before deputy commissioner. Then
deputy commissioner, there is a separate procedure. How can a magistrate say that you confiscate because it is an explosive? If it is an explosive, police will investigating authority may put it in the custody of the.
the language is very
IOC.
clear, my lord. When a commodity seized in personal order made under section 3, in relation to a report of such seizure shall without unreasonable
Art
delay.
Mr. P. Kotoke, learned counsel for the petitioner. The present application is filed assailing the legality and validity of an order dated 13/7/2023 passed by the learned judicial magistrate first class Shivsagar in Gaurisagar PS case number 90/2020 arising out of PRC case number 111/2023 under section 120B/379 411 420 of IPC read with section 7 of the Essential Commodities Act 2010. Full stop. 10, comma, whereby while rejecting the Jimma petition of the petitioner, a further direction was issued to initiate confiscation proceeding relating to 48 numbers of drums containing burnt mobile/industrial lubricant. Mr. Kotoki submits that when the matter involves the provisions of Essential Commodities Act, the learned judicial magistrate first class shall have no power to pass such an order for confiscation inasmuch as in terms of the Essential Commodities Act, it is the investigating officer who is to seek permission from the deputy commissioner for the confiscation. This matter needs further consideration accordingly to notice returnable on
On, my lord. 12 of September.
12th of September 2023. Till such return, the impugn order dated shall remain suspended. In the meantime, the investigating officer shall furnish a report whether such such said product is dangerous for public health and public health for keeping the same inside the police campus, and whether the Jima of this material can be granted to the petitioner. To the list according.
Mark.
Give a date. 12th.
12th.
Yes.
May I please? Application for deduction of maintenance. Lordship. Here, my lord,
Huh? Item
1-5 Lordship. Mrinal Mahanta.
yes.
Here the respondent
Hmm.
wife is a government employee. Lordship. Her monthly salary is rupees 44,919 Lordship.
Yes.
And the
And what do you do?
Lordship, I have challenged only one part. Her child receiving rupees 1,000, I have not challenged that part. But she is receiving an amount of rupees 800. 800.
What do you do?
So then notice may be issued for
No. What do you do? Where is the order if you order?
improvement order. Lordship. Page number 63 Lord.
Yes.
I am a random worker, Lordship, not a permanent job or any permanent business. Sometimes I am working as labor, Lordship.
It's notice and interim. On notice on interim. Returnable after 6 days by 4 days, 5 days.
All right.
Yes,
Well,
Mr. Paul.
This revision is preferred against the conviction of the present petitioner for 2 years in connection with the Sessions case number 12 passed by the Landed Secretary Jora for a period of 2 years.
Why it should not be enhanced and notice should not be issued to you? Your case of 30.
No, it has been converted to T04, but I am praying for a complete acquittal by challenging the evidence.
Evidences are there that you beat him up and he died due to injury, head injury. Why 304 part 2? Where is the sudden provocation? Where is the evidence of sudden provocation?
But there are so many grounds we have raised in this revision, which is yet to
So
be
let
heard.
us issue a notice
Heard
why
on merit.
it shall not be enhanced.
My lord. These grounds to be considered.
Because he was a alcoholic, therefore,
No, I am not alcohol.
no, he other
Yeah.
other person.
Yeah.
304 part.
Right.
And that is also not preferred. Okay. Hard. All right. No. What corrected?
LCR में भी कॉल
हाँ?
LCR में
LCR. What? Means separate application.
I have made an interim prayer for suspension of sentence.
Considering the method and the period of sentence. Are you on previous bit?
I am out.
No. Out is something and you are on previous bit. That is something different.
statement
Yes,
दिखाने
yes. I am previous.
We are typing it different.
Yes.
In the interim. Till return of such notice. The is allowed to remain on the previous bail granted to him during the trial by the learned. Yes,
My lord, this matter may be passed out for the time being.
not time being Friday.
Friday.
Wait, please, Your Lord.
Yes.
My lord, I'm for the quashing on the ground of my lord compromise between the informant.
Rokibul Islam.
Yes, my lord, he is the accused number one, and another is accused number two of the affair, my lord. My lord, ultimately, charge sheet has been filed, my lord, and case cognizance has also been taken by issuing non-valuable warrant of arrest on the first day, my lord.
Hmm.
But the thing is that my girl is 15 years, my lord.
Hmm.
When, my lord, but
Who made the compromise?
the informant, father,
Can a father compromise on behalf of a victim girl?
but ultimately, my lord, some judgment of Honorable my lord Rajasthan High Court and the Supreme Court in
There
appeal.
is a judgment offered by this court sitting in Kohima.
Right.
This is squarely covered by this. Dismissed.
My lord, another ground I have taken, my lord.
Yes.
On the first day, the learned court
And NPWA, no problem. You appear, will suspend it.
Yeah.
Here's the trial. So for compromise, it's rejected.
that may be,
Cannot be done.
proper, my lord, my appearance.
NPW. When is the next day?
It was 11/8, my lord, but next date I have to
Okay. Within a
within
period of
10 days.
appear till then the NPW issued shall not be executed. To prefer bail application,
All right.
compromise. In a yes. It's good. Item? Yes.
The quashing of an affair or the affair is a case 14 is the affair law. What happened in this case, Lordship, one Krishnani, he purchased some metal nut on government auction. Thereafter, I'm a transporter, Lordship, and it was supposed to be
19.
20. As a transporter, I was supposed to transport the material. Now, on suspicion that those are stolen property, police seized the material. Now, one informant who is Jazbir Singh Tupia, he happens to be a broker. He took the charge to transport the material to Nagpur. Now, he filed an affair stating that I have sold the material in the open market by releasing the material by submitting false documents. Whereas I have annexed the document.
Can you decide all those things in a 482 application?
Yes.
Because there is no allegation made out in this offense, in the affair law.
What is your name?
I'm Jayaprakash Sharma.
Affair is at page 14.
Yes, Lord.
Your name is?
Jayaprakash Sharma. This Krishnani, he is the owner of the supari, which was paid. Now, he did not file any affair. Now, allegation is got by the informant who is a broker.
Just give me a minute.
Lord. Sorry.
You are Jayaprakash Sharma.
Yes, Lord.
Now, how do you deal with the last page?
Yeah,
Up
that is
to
the
up to the
page 14. There is basically no allegation.
okay.
No offense is considered.
Now they
Yes.
say that it was purchased and it was used to transport.
Yeah.
You keep it in your footer.
Yes.
Rightly, wrongly, police sees it.
Says that.
You ask them they don't come according to this. Don't
Register
come,
that.
police will arrest it. Okay, up to that there is no offense
No.
made out. Fine. Now, according to them,
Not
you
with all respect.
you claim the claim to be the owner of the betel nut, filed Jimma petition, got it released and sold it to others.
That is the misrepresentation of fact.
Where do you get that?
Lordship may turn to page 32. Krishnani, the owner of the property, he did not lose any affair. Page 32, the owner of the betel nut, Krishnani, he filed a Jimma petition, order was passed. And
Where is that?
Page 32, Lordship. Otherwise, that would have been an offense. But page 32 is clearly belies that allegation. Jimma petition, next second paragraph. Lordship. Page 37, Lordship will find the operative part. Now, Krishnani, the owner of the property, we received the Jimma as per court order. Now, allegation is that I submitted forged document, I have taken Jimma and I sold it in the open market. And Krishnani did not file any affair.
Yes. Whatever.
My lord, now from the because this is a 482 application, so I will have to go by the my lord contents of the FIR first, my lord. My lord, there are according to the not only the question of my lord, who is the owner, my lord, how they my lord illegal transfer,
There
but
is a
regarding
question will remain whether the same betel nut or it's something different. But I think he has been able to make out.
so in that case, my lord, I will have to my lord
Obtain,
call for the case.
call for the case.
Case there.
Or Mr. Arnett, not Mr. Present application is filed for passing FIR dated. Passing the investigation proceeding arising out of Sangsari PS case number 442/2022 dated 17/11/2022 registered under 419, 420, 407, 468, 471 of IP. The Learned Council, the Alam, submits that petitioner is only the transporter order of the said Ereka Nut, and the said Ereka Nut has said Ereka Nut, Jimma of said Ereka Nut has duly been granted by a competent court to the owner of the Ereka Nut, namely, is he a respondent?
Yes, no, Lordship. He is not an affair, so I made the informant an affair.
To its rightful owner. However, in the FIR, it has been alleged that the petitioner has obtained the got the Jimma of the aforesaid Erekanat impersonating himself as owner of the state food. Full stop. In support of his contention, Mr. Alam refers the order dated 27 to 20/07/2022 passed by the learned additional CGM Kamrup Amindao, which shows that the Erekanat was custody of the Erekanat was directed to be given to the registered owner, and the application was filed by the one Vijay Imatrai Krishnani, whose name also finds a reference in the FIR, impugned FIR, and in which it was admitted that the purchase was made from the aforesaid Krishnani. In view of the aforesaid fact, this court is of the prima facie view that the petitioner has been able to make out the case. Accordingly, Mr. Kothakul shall produce the case diary in connection with the case, and it is till then it is provided that though the investigating authority may proceed with the investigation, however, no coercive action shall be taken against the petitioner.
I'm on bail.
And you're on
Bail.
bail. Okay, so not
No,
necessarily,
not
not necessarily.
No problem.
On my lord.
Give a date.
26/9.
9.
9.
May I please, Lord?
Yes.
Lordship, is the 482 application for
Yes.
setting aside the impugned order dated 9/3/2023.
Are you owner of the vehicle?
No, Your Lordship, I'm the financier of the vehicle.
So can a financial be granted?
No, Your Lordship. what
Nobody
happened-
has come forward.
No, Your Lordship.
His case is that owner is not coming. Ultimately, loan will not be paid.
Yes.
At least I can take, but you cannot sell the vehicle. What will you do with the vehicle?
Your Lordship.
You have other option to recover the amount from the loanee. Why should the custody be given to you?
Your Lordship, what happened in the respondent number 2, he has defaulted in making payment of the loan. We have sent demand notice to him also, but he has not responded. And this vehicle has been lying since May 2022. So it may damage the vehicle, Your Lordship.
Okay, okay. The present petitioner is the financer of a seized vehicle, which was seized in connection with
Sanctuary PS case number 205 of 2022.
to 2022. According to the petitioner, the owner of the vehicle has defaulted in payment of loan, and already demand notice has been issued to him. However, neither he has paid such overdue amount, nor has he approached the court for Jimma of the vehicle. In the aforesaid background, the financial the petitioner as financier applied for Jimma of the vehicle. However, same has been rejected by way of the impugned order. Impugned order. In the aforesaid backdrop, but we will have to hear the actual owner
Yes,
will
sir.
issue the
Yes,
notice.
notice
This is
to
a
the seller.
disputed case.
Yes.
With the in view of the above, to notice returnable on
On my lord. 29, my lord.
29th.
20.
The Bothakor accepts notice on behalf of Bothakor.
Yes, my lord, on behalf of my lord, respondent number 1, my lord.
Respondent number 1. Notice to respondent number 2 within 5 days. In the meantime, Bothakor may obtain a report of the investigating officer. We'll see on that day if he
Yes.
appears. Otherwise,
Apply.
the petitioner is also
29.
permitted to take the
22,
petitioner.
9.
However, same will be routed to the Yes, item number.
Lordship, FIR is in page number 10, Your Lordship. In this matter, Your Lordship, the petitioner number 1 and respondent number 2 were married in Mumbai on 4/12/2017. And later on 14th
the
February 2020, the respondent number 2 went back to her home saying that she needs a break. But at that time, the entire nation was going for a lockdown and COVID has hit the nation. So the petitioner number 1 and father of petitioner number 1, petitioner number 2, they telephoned respondent number 2 to come back, but she put a condition that she will only return to her matrimonial home if petitioner number 1, her husband, lives separately with respondent number 2. And in order to save his married life, the petitioner number 1 gave up to her demands and started living separately. Then, Your Lordship, on 28 May 2021, again, some quarrels between them has arisen, and the respondent number 2 has left her matrimonial home. And FIR was lodged on 23/11/21, Your Lordship. Bail was also granted because the FIR was basically a vague FIR. It's only a one paragraph FIR, and nothing is clearly mentioned in this FIR. And because of that FIR, the petitioner number 1, including his
How,
parents, has to
what do you say about this? Before marriage, my father-in-law, my mother-in-law, along with my husband, had demanded cash amount of 250 and gold jewelry.
completely baseless, Your Lordship. There is
So can we decide whether it's completely baseless or fact or in a political petition?
Yes.
What is the law in this regard? Then
Lordship,
after few months of marriage, they again started demanding various articles, including gold ornament, which I conveyed to my parents over telephone. But when my parents refused to provide their demand, in turn, they have started torturing me physically and mentally since 2018. What more you require?
Lordship, in Devilal and others versus State of Haryana on 29th October 1992, Punjab and Haryana held that there was not specific particulars regarding time, place, and manner of any beating, cruelty, or harassment, as well as demand of dowry. And in circumstances, it
Well,
cannot be said
here
that
specific demand of dowry is there. 251 and subsequently.
they're mere allegations only, Your Lordship.
That we understand. Whether that is mere allegation or not, investigation will say.
Lordship,
Charge sheet file.
not yet filed.
So
Lordship, notice may be issued at
no. It's a case of dismissal on day 1. Anything to argue? Bhajan Lal. We'll quote the Bhajan Lal and dismiss your petition. Dismiss.
Case diary may be called, Your Lordship.
Dismiss. Hey, yes.
May I please, the Lord? My Lord, in this case, I am challenging an order of the additional session judge, my Lord, page number
Item number
22. Impugn order, my Lord, page number 29, my Lord.
29.
Second paragraph, my Lord. Is directed to deposit 20% of the compensation amount.
What the law says?
My Lord, kindly come to page number 25, my Lord. Third paragraph, my Lord. The order of the trial court has already been stayed by this court, my Lord, by the learned appellate court, my Lord. And till disposal of the case, my Lord, this order has been stayed. Now, my Lord, subsequently, my Lord, they cannot, court cannot direct to pay 20%. Since it has been already stayed till disposal of the case, my
Who has any law? What is
And-
the meaning of 148?
Lord.
Whether it's mandatory, whether it's directory.
my lord, page number 31.
Page?
Page 31.
Yeah.
And 148, my lord. May I read, my lord? 148.
Yes.
My lord, in this case, learned appellate court, my lord, review its own order. That is one aspect, my lord. And in respect to 148, my lord, notwithstanding anything contained in the Code of Criminal Procedure Code 1973, an appeal by the drawer against the conviction under section 138, the appellate court may order the appellant to deposit
What is the next date?
My lord,
What is the next date?
29, my lord.
29.
My lord, 29.
We'll take up the matter on Friday or
Yes.
Friday. We'll do some research. It will not be a review because it's a special provision enacted.
Yes.
What is the object of enactment of this provision? To give an interim protection. The word used is may. Court may, court may not. Suppose the court exercises discretion to interfere under 482, there needs some ground. What is the illegality committed?
My lord, there is some, my lord, one ground, my lord. My lord,
Today itself or Friday? Friday, when I don't have any confidence on this issue.
Yes.
No, I'm not saying confidence, but I'll have to see what is the present position.
Yes.
Many cases are pending. We'll club all together and decide.
Yes.
And in many cases, stay. The provision, there is an object of this provision.
Yes.
We'll see the statement and reason of incorporation of this provision.
Otherwise, my lord, within a period of 60 days, my lord, he will have to deposit that amount.
That is first.
Yes.
Second thing, question will arise whether it will be a review. According to prima facie view of this court, this is not a review because that is a totally different. The judgment has not been reviewed.
Yes.
It's an additional thing in exercise of power under 148.
Yes.
So it's not a review. Court can very well do at any stage.
Okay.
Third issue comes, the important issue is may. If may means when court will give. The discretion should be judicious. Under what circumstances? What is the law? Any law of the Supreme Court in this regard? When? Under what condition?
No, my lord.
Anything have you gone through?
Their department, another wrong has been committed, my
No,
lord.
what is that wrong?
My lord, appellate court has directed to pay 20% of the compensation award, compensation amount, but trial court had not given any compensation. Trial court even given, my lord, fine amount.
Oh, these are use of what?
My lord, compensation is expressed in section 143, my lord, and 130
Okay, we'll hear you on
Yes.
Friday. Come prepared.
obligement.
Monday, 28. Monday.
Obligement.
Is this matter? On 28. As straightforward as I can put it. Oshakul, just have some ideas.
Yes.
We'll do the research. I was thinking of doing some research on it.
May I please lordship? My lord, for 39 application, my lord, case there was call for my lord.
Is there a receipt?
My lord, FIR page 10, my
Hmm?
lord. FIR page 10, my lord.
Arrested on?
My lord, arrested on my lord 31/7, my lord. Two allegation, my lord, in the FIR, my lord. First, my lord, I took an amount of rupees.
Oh, you called the person to Delhi.
Yes, my lord. That is actually, my lord. Not to my lord.
Huh?
It was not sent through my email, my lord. It has been alleged that, my lord, through my email. My lord. That is not there. And my lord, second part, my lord, I, my lord, took an amount of rupees 10,000 and my lord, golden chain, my lord, forcefully, my lord. That is also not, my lord. 10,000 rupees, my lord, recovered, but that is my mind.
material.
My
How many days?
23 days.
23 days, my lord.
To the satisfaction of
CGM computer. Laptop. I love that.
everywhere this is. And offenses are all 5 years.
Shortcut is like.
Yes, madam, what is this?
Lordship, it's an application report that it pre-arranged. Lordship,
Good.
FIR is on page
My lord,
number.
29 may kindly taken up after some time, my lord. I will have to get some from my lord. File is also not.
After something.
Thirty, my lord.
Thirty.
Case diary not received.
Who is there?
Up to date.
AB,
AB, my
DP is there.
no, well, three not.
Interim is there.
Interim.
When?
The city on my lord. On 29th of September.
Is there for this matter on
29/9.
for product?
41, my lord, as far submitted. FR.
We submitted that investigating authority has filed final report after completion of investigation. Accordingly, nothing survives the adjudicated. According
FR white number 12
file FR, final report white FR
12/23 dated 29/6/23. 34 may kindly be taken up after some time.
yes.
As per the interim order, we have already appeared before the High Court.
What
In
is
this
the-
case,
what is
you have
the
taken the fact which has led to file this FIR is apparently that the informant, he is a contractor, and he was awarded contractual work in the state of Arunachal Pradesh.
Hmm.
So what he did, he appointed one Teshi Gudun Tara hailing from Arunachal to look after that contractual work, as well as to open a bank account and to operate the same. And on the basis of the state power of attorney, the Teshi Gudun Tara, he opened a bank account in Arunachal Pradesh FX Bank Limited and operated the same for certain period, and then he closed that particular account. Now the FIR has been filed by the principal.
Yes, what is the case? Yes, fake account open.
Yes, my lord, as per the allegation, my lord, my lord, the present accused person has earlier, my lord, there is some contractual obligation.
That is a
with the party.
different
That is a
issue.
different thing.
That is a civil.
And he is the-
but specific allegation is that
Uh,
some fake GST
uh,
account has been opened in his.
as per my lord, he is the branch manager of the Arunachal Pradesh Cooperative Apex Bank.
Okay.
He,
Oh, you are the bank employee.
I was,
bank manager.
your lordship, I was
On the basis of my lord, earlier, while my lord, that contractual obligation was going on, one current bank account was running at SBI. And that, as per the allegation of the informant, in that he has earlier provided one power of attorney for opening a bank account for that contractual obligation. Later on, my lord, he revoked that power of attorney as per his,
Okay.
and thereafter, my lord, this bank account has been opened in the name of informant without his knowledge. And in that regard,
He
he
has
appeared with
cooperated.
statement record.
Statement recorded.
Yes.
Absolutely. Interim order. Is there?
On 11/7/20.
I thought he is the partner of the company. He's a bank employee.
He's a branch manager of
Branch.
Arunachal Pradesh. Arunachal Pradesh State Cooperative Apex Bank.
Yes.
CD available, madam.
The senior counsel, Mr. P. J. Sekhar, is on late, Your Lordship. I pray that the matter may be passed over for the time being.
What is the allegation?
Matter is regarding
Lottery.
Illegal lottery.
lottery, my lord. He appeared, my lord. His statement also recorded. He said that মোক কমিটিৰ কোনো লোকে জনোৱা নাছিল ইমান তাৰিখে লটাৰী খেলখন হ'ব বুলি মই কোনো সদস্যক মাতিছিল মাত্ৰ মোক তেতিয়া তেওঁলোকে তেতিয়াই মোক কৈছিলে মই লটাৰী কোনো জড়িতও নহয় মই ইয়াৰ কোনো জাজো কৰা নাই মোক ফচাবলৈ ৰিকুৱেষ্ট কৰিছে
Considering the nature of allegation and material collected by the investigating officer, and also considering the fact that petitioner has covered the activity. Why you need your senior for? Yes, next 30.
37 মানে 3 not 15 মানে he's an
Interim.
interim is there
When?
পরলো মুখ মানে first week of September 11 মানে
September 11. Interim.
কেসের রেজিস্ট্রি মানে
What is the affair?
11 law.
allegation is they demolished one house मतलब earlier father of the accused persons मतलब allowed the informant to live in that place on rent lease basis subsequently मतलब he himself after मतलब menaced some papers in the name because of that मतलब আমি ভাঙি দিছিলো and now मतलब all of them all 4 persons मतलब they all appeared your statement recorded. Civil nature.
Apply. May I pick the lordship?
39 CD receive madam.
What is the affair?
FIR is 11 law.
One vehicle was taken to Toboka and thereafter forcefully it was taken. He is the driver. He is the driver of the vehicle and owner of the vehicle lost the agent. Now the driver he said that as per the instruction of the owner, I have taken that vehicle along with this person and subsequently in the middle of the road after lifting the boca, however, understand the night, few person along with the person accompanied with him in the vehicle, the boca rob and stayed vehicle along with my mobile phone and belongings and threatened me. Later on, villagers rescued me. So,
He is
he's
victim.
he's a driver, owner stated that he may have some
Link.
villagers rescued.
Apply.
May I please, your lordship, I am extremely sorry that my item has already gone, my lord.
If it is
And
gone, it is gone.
Item 30, my lord.
If it
CD
is
was-
gone, it is gone. It will come later on. You'll have to wait.
30.
Obliged, my lord, 30.
Already AB series is not available, so already date fixed.
Date fixed, no? Obliged.
Please, it's a request. Don't jump
Sorry.
in between a proceeding. If you have something to
Sorry.
say, you have missed it, we'll recall our order. But don't do this, and time and again I'm saying it.
Obliged. I am sorry, my
Don't do
Sorry.
that. There is a decorum of the court. Anybody will come anytime and say, no, I was in so and so court. I missed it. That is
Fine.
not appreciated. Yes,
40 मतलब CD not received मतलब reason interim मतलब.
interim when
Sanmari. Sanmari मतलब on 11th of September मतलब.
11th of September. Interim.
Page 12, my lord, if you have
Lordship, 41, 42, and 43, Lordship, same petitioner, Lordship.
41, 42
42,
and 43. What is the allegation? What is the FIR?
Page 12, my lord, in item 41. Sir, nobody is named, my lord. Allegation is, my lord, Easterland of my lord, battery of tower, mobile tower.
Oh, that case.
Yeah.
How why they are apprehending?
Lordship, already charge sheet filed, but their name are not there.
Hmm.
And further investigation is going on, Lordship, till that their involvement is
Till
not-
the no
no
involvement.
involved.
So,
Only Lordship, Abdul Noor Lordship, petition number 1, Lordship,
Hmm.
they sold to his shop, scrap shop, sold the
Yes.
stolen material to the shop of
Once police
Abdul
have-
Noor Lordship.
so all are Abdul Noor. Why
Abdul Noor and
Abdul Noor and his son.
two,
why three bail application?
3 different cases registered. 3 of us.
So in that elega three offenses committed.
3 of us.
In all the three cases preliminary search sheet has been submitted.
2,
And
my
they are
lord,
not named,
No.
and investigation is still going on. Okay. Past hard is an application. The learned additional public prosecutor
PSKs are different. Lord.
will see. I am on 41.
Okay.
Submit that already search sheet, part search sheet, no?
Part, sir.
Part search sheet has been filed. Or search sheet, what say?
Charge sheet,
Search sheet,
charge
part
sheet,
search sheet is now condemning. Supreme Court is also saying, don't do. Search sheet, file search sheet being in item 41.
11/3/23. Start sheet date. Start sheet number 12, service submitted on 12/4/23, number 45 of 23.
Then why have you filed AB?
charge
Yes,
sheet
part
number
search sheet,
45
therefore.
public 23 dated 36
Yeah,
23.
Your name is also not here.
Not.
Then why, what is the
Police, one occasion police came to my home.
the present application is filed on the apprehension that the petitioner may be arraigned and accused and may be sent for trial subsequently, though the search sheet has already been filed and the petitioner is not named accused in the search sheet. In that view of the matter, in the considered opinion, no order needs to be passed in this application, as already search sheet has been filed and the petitioner are not sent for trial. With the aforesaid observation, this evidence is no need to give any search sheet.
In item, my lord, 42,
Hmm.
no search sheet, only FIR.
No, she says the search sheet has been filed.
Okay, out of 3, 2
Okay.
search.
41 is gone, then 42
42 is also, my lord, part search sheet.
search sheet. We'll
40
take search sheet.
Lord,
And which one is no search
43.
sheet file? 43. When you file this application?
Yeah.
Okay, 43 you write down that learned additional application under the learned additional public prosecutor MS Pensu submit that already search sheet has been filed in this case and the petitioner is not sent for trial. In that view of the matter, nothing survived to be adjudicated in the present application according to them.
Abla.
Lordship, CD not received.
41 and 48. Search sheet about it.
My lord, I am on interim.
Interim is there, Lordship, CD not received on Lordship, 18th of September, Lord.
18th of September.
My lord.
Interim to continue.
My lord.
45 also, Lordship, CD not received, Lordship.
My lord, in this connection, in this case, my lord, 8 persons were arrested and they have been released on bail within the
So you want to get arrested and want
no,
bail?
no, my lord, no,
Then
my lord, 2 year punishment.
it seems like that 2 years punishment. For what are the offenses?
Allegation under section 143 353 and
Where is the FIR?
FIR at page number 15, my lord, particular.
Page
15, particular. May I read it?
yes.
মহোদয় সম্মানপূর্বক এজাহারকারীর বিনীত নিবেদন এই যে মই ময়রাবাড়ি থানাত কর্তব্য থাকো ইংরেজি 2/8/2023 তারিখে সন্ধিয়া প্রায় 6:15 মান বজাত ময়রাবাড়ি আমার দৈনিক পঞ্জির নম্বর 32 তারিখ 2/8/2023 মর্মে ময়রাবাড়ি থানার উপপরিদর্শক দীপক চক্রবর্তী আৰু সংঘীয় আৰক্ষী সহ মই ময়ৰাবাৰী বজাৰৰ সমীপতে বিভাগীয় তালাচী কৰাৰ লগতে মটৰ চাইকেলৰ জৰিমনা কৰা কৰ্তব্য কৰি থকাত AS 21L0340 নম্বৰ স্কুটিখনৰ চালকজনে হেলমেট পৰিধান নকৰা ও নথিপত্ৰ নথকাত উক্ত স্কুটিখন থানা হেফাজতত ৰাখিব কাৰণে আনিব বিচৰাত উক্ত আসামিগণে নানান ধৰণৰ ভয় ভাবুকি দেখাই আইনত মোবাইলত ভিডিঅ' কৰি মোক কৰ্তব্যত বাধা প্ৰদান কৰে আৰু মোক শাৰীৰিকভাৱে
Yes, madam.
my lord my name
These are the cases registered. Okay. City is not, city call for is not present. Considering the nature of allegation, it provided that the petitioner be released and paid as an interim measure. In the meantime, the petitioner shall appear before the investigating authority within a period of 2 days.
obliged, sir.
46 also same FIR.
Huh?
46 same FIR.
46 same affair.
Same.
Next case.
Next case, sir. Same.
You are the pillion writer or what?
No, Lord. I am nearby shopkeeper, Lord.
These cases, wastage of judicial time.
Only.
Huh? Automatic.
Seriously, Lordship.
My lord, I am on interim, my lord. After interim, we have appeared before the IOM.
Lordship, they have appeared statement recorded.
No necessary, not necessary. Okay. Appeared, cooperated, and also considered a matter. Both.
Both, my lord. Absolute and disposable.
In this case, one particular PS 710 was called for. 50 times we have sent message, not the thing. Now I have come to know that it has been transferred to Jalukbari PS. Because of that, because of that three notices, now I have asked my office clerk to clarify that, to collect that number. Then Jalukbari PS PD may be called.
Can
for.
you do it today?
Yes, ma'am. Yes, ma'am. No, yeah, Jalukbari logo is ma'am. After some time, just we have called
My lord, 2 numbers of police station, why I am personally appearing again and again.
No, already one,
Because 2 numbers of FIRs.
one
Two
FR.
FIRs has been filed in 2 police stations, that is one in Panbajal police station and another one is Nagaon Sadar police station. The Panbajal police station is submitted the final report. It is about more than 14-15 months back. Till today, CGM court could not able to submit notice to the complainant because the person either not receiving in his own name or the police is not submitting the notice. This is, and again the Paltan Bazaar police station, I have went to the officer in charge for at least 12 times. Personally, I requested him that notices has been submitted from the court. This is the condition. Either you submit your final report, charge sheet, whatever be it is. He is doing nothing. He is saying that
Now
the
we are coming that case has been transferred to Paltan Bazaar.
Sir,
So
after
we
the
are calling the Paltan Bazaar police case diary.
No. Jalukbari.
Jalukbari. Now you wait, we'll have it at 2.
Till
Thank you,
now,
my
my lord, only that is verbal instruction, my lord. And regarding the, my lord, content, I will.
What is the case about? Some causing or what?
Yes, quashing of the FIR, there are some specific allegations against the present accused person, my lord.
Ah.
And
Let
my
us
lord,
see the investigation because all two cases filed. One is given final
that
report.
is final report submitted. my
So
lord.
if final is, let us see.
At two, my
She is not appearing.
Yes.
Yeah, this may be a case of harassment. Let us see. Can we have a two?
I will
He
try.
says
Yeah, I will
he's
try, my
coming.
lord. I will
You try it, we'll have it.
Thank you, ma'am.
Forty-eight, my lord, in this case, actually, Sasti submitted earlier, my lord, directed against whom Sasti laid, my lord.
Hmm.
Sasti was laid against the main accused Alaluddin, my lord.
And what
Other, my lord, he is Mirajul.
is Mirajul Islam?
My lord, against him, Miraj. But here Mirat Ali written Mirat Ali, Afia Khatun, Aisha Khatunর কোনো ভূমিকা নাই। Miraj Ali, Mirajul Ali is a Mirat
It
Ali.
should be, I think, same base, no. Okay.
Against the only that
Okay.
who
He
killed the-
submitted the investigation ended with a search sheet wherein search sheet being search sheet any number.
Yes, my lord,
Search
search
sheet
sheet
being-
number 09/23
Hmm.
dated 31/3/23.
2020 wherein the present petitioner is not petitioner or petitioners petitioner is not sent for trial in that view of the matter. Nothing survived in the criminal petition according to the same court.
1490 April.
May I please on notice?
Yes.
Kindly pass over the matter for time being.
Why?
Engage counsel busy in another court.
And this council is another court. Supplement. Service report.
Yes.
Okay. In view of office note date, Peru's the office note dated 16/8/2023 and also the service report submitted from the office of the chief judicial magistrate to be also service in respect of respondent number 2 is complete.
Right.
Accordingly, what is this matter? Criminal appeal.
My lord, criminal appeal, IA is there also.
Okay. IA for bail.
My lord, suspension of
What are the offenses?
under section 370, subsection 2 and 34, my lord. It is, my lord, told the victim girl to the, my lord, hotel and used as her
Do you want
prostitution.
to file any objection here?
No, my lord, here 7 years conviction.
7 years.
Right.
Okay. List this matter on. Give a date when your senior will be free. Give a date. Murthy. List this IA
My lord,
on 30th of September.
my lord.
May I please?
Yes.
All for my lord, not receive my lord as per office note, my lord.
Registry to issue reminder for the compliance of order dated which order?
5/6/20.
Order dated 5/6/2023 passed by this court. And reach this matter after 3 weeks.
First week of
Reach this matter the first week of September.
May I please?
Yes.
My lord, here in this case, my lord, the petitioner is a sub-inspector of police.
Mm.
One FIR was lodged against the petitioner alleging that the petitioner, while he was on patrolling duty, my lord, he assaulted two staff of a toll gate, my lord.
Hmm.
That FIR was culminated into searching, and ultimately, my lord, the learned CGM Bajali took cognizance against the petitioner and issued summons to the
What
issued
was the
summons,
ground sanction?
my lord.
What
So,
was the ground?
But my only ground, and I'm confining I'm confining to the cognizance part, my lord. That the cognizance was
Without
taken.
sanction.
Yes,
That is your ground.
yes, but that is the ground. And even the law also say that in case of a public servant, in any offense, court cannot take cognizance without sanction of prosecution. Well, that is the law. There is a very clear provision in section 197. And there are very specific decision of the Honorable Supreme Court, and this court also in 2023, one decision was reported of this court, my lord, wherein I was also one of the counsel, my lord. I was the counsel of the petitioner side. The
Was
decision,
it?
my lord.
To
Not
the
only in one case, my lord, several cases were disposed of in 2022 and 23 on similar matter, my lord, wherein I was the counsel, my lord. But I'm referring some petition and Honorable Court, my lord.
today is only orders, their service not completed as per office note.
It's so taken, and ultimately, my lord, respondent informant, my lord, he will have nothing to say because the issue is here only confined to the cognizance part, my lord. That the cognizance was taken by the learned CGM without sanction of prosecution.
What is the duty of a police?
The duty of a police is to maintain law and order.
Law and,
Law and order.
and to beat people.
Even, my lord,
And to beat people in execution of law and order duty.
my lord, in one of the
And
decision
to
of the,
demand money from that toll gate.
no, there is no allegation of demanding money, my lord.
Okay.
No allegation of demanding money, only allegation of assault money. Firstly. Secondly, in one of the decision of the Honorable Supreme Court, the Supreme Court said,
Hmm.
even in that case, my lord, some police personnel were involved in killing of a person, my lord. The High Court did not interfere with the affair. Then ultimately, Supreme Court said,
Hmm.
if the High Court does not interfere with the matter,
If there is a law and order situation, is if there was a direction to magistrate direct to fire, if a person is killed, that may be a duty.
my lord,
But going to a toll gate,
what happened at night?
Hmm.
The petition was,
what happened we cannot decide here. That is the problem. Otherwise, we would have decided many things here.
what the affair say and what the record say, my lord. Because GD&P is there. Petitioner went to patrol and duty with the Central District Patrolling.
Who are the
Station.
informant?
My lord, even the petitioner, while he was on patrolling duty at night,
Now tell us the law. Is it
My lord.
necessary to
My
hear the informant?
My
No,
lord.
no.
No.
We'll,
what the CRPC say, my lord. What the CRPC says, section 197.
no. That is
Regarding
not. Now
informant.
we want to be enlightened
My lord.
whether informant is necessary in this case to be heard.
No, my lord, only I am confining to the part of cognizance, my lord.
No.
Suppose
First of all-
we set aside this
Well,
order.
well.
Is
Well-
it necessary to hear this
My lord, only that
informant?
part, the Honorable Court can take the decision.
No, what is the law? Let us get enlightened.
So, my lord, on the part of the service, my lord, and hearing the second party on the informant, my lord, that part only court will do. Otherwise, my lord, on law point regarding the cognizance part,
So law point we can decide without
hearing the informant.
without this man being here.
My lord.
lordship can
That is the law.
my lord, I am not on that.
You are not on that, but we will have, if we will have to proceed on hearing, first we will have to answer this question. That though notice
It's also taken, my lord.
must have taken.
Yes.
Service report is awaited since it involves a question of law under section 197.
Yes.
There is no necessity to hear this person. So
No, my lord, I am not submitting on that.
then
My lord, fix it for that, my lord. Otherwise,
in view of office note dated office note dated 19/8/2023 await service report. Any case diary received?
My lord, here in the cause list it is shown as one file receipt.
Okay, I'll share scan copy of
Receipt.
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 Let me see that. You keep this husband for the next day.
my lord. And my lord, may keep it short date because the matter is fixed before the lawyer court, my lord, on 22nd of September. So before that date, my lord, people lordship is pleased to, my lord, fix a date for date before the 22nd of September. My lord, because on the last date, my lord, I submitted one petition before the CGM Bajali.
stating, my lord, regarding the pendency of this petition, and the honorable court here, my lord, till the date on 22nd of September.
Okay, all statements are there of your friends. Go to it.
My lord,
Of all of your friends
No.
who are there,
present.
your
Present
present,
at the-
including your constables and all.
My
Go to it on the next date and mark it.
my lord.
Yes, next, yes.
10, 12, 15,
Pali,
10
give
or
a, give a
12
date, give a date. After 3 weeks, give a date.
After 19. Highly already.
The time we have.
Lordship, the charge sheet case, Lordship, similar to that three case, Lordship, 41, 42, and 43.
Okay.
Here, Lordship, his name is not charge sheeted, but his involvement is
We do not know if he is not sent for trial, not sent for trial. Okay, I got it. Huh? Not sent for trial. Charge sheet being
Lordship, charge sheet number. Charge sheet number 44/23, dated 30/06/23.
for your
Lordship, in this case, your lordship, Mr. TPS Aikya senior counsel is appearing in. He's on
Uh-huh.
next. Some accommodation, your lordship. The plan.
What was the
Maybe
issue here? What about?
My lord, in this case, my lord, in the name of providing, my lord, paperwork order for hiring vehicle in ONGC, my lord, the accused persons, my lord, he along with other two accused persons, my lord, one Kanai Mondal and my lord Ram Prasad Shah, my lord, they collected huge amount of money from various persons, my lord. All those victimized persons' statement is also available. And regarding the present accused also, my lord, there are individual complaints filed by the, my lord, victimized person, my lord, how he is
Okay, at two.
involved along with the record.
At two.
As per last order dated 22/6/2023, my lord, this honorable court directed the petitioner, my lord, to give 10,000 rupees per month. My lord. It was
What do? You are at CISF,
my lord.
something like that.
My lord.
What is your salary?
My lord, salary, my lord, 53,000, my lord.
53,000.
And after deduction, my lord, he received, my lord, 27,000.
What are the deductions?
My lord, there was a two loan, my lord, that was prior to marriage. And I have given them, my lord, affidavit before the
Okay,
MD court.
well, two loans then.
Lordship. And out of 27,000, my lord, my father and mother, they are ailing, my lord. I have all medical
No, no,
documents,
we believe
Not-
everything. You get 55,000,
53, my
53. Then your deduction of loan.
loan, my
Loan
lord,
for what?
one personal loan and one, my lord, car loan.
Car loan. Sell out the car. Then,
That was before, my lord, marriage.
okay, now we'll have to sell it out. Because you cannot, you have not been able to maintain. Okay, then what are the other loans?
Other, my lord, one personal loan for house, my lord.
Okay, personal loan for house. And children, what
My-
was the given? 10,000?
10,000, this honorable court
Total given
15,000.
15,000. Wait, we are recalling this order, 22/6.
No, my lord, lordship, here is a, my lord, like a expert order, my lord. You lordship may remand the matter. I may be given the opportunity, my lord. One day, my lord, not a single
But we'll
day,
have to, we'll see that, but this
Not-
last order reducing to 10,000,
not a single.
we'll recall it.
that also he had not paid, only 8,000, my lord.
And whatever,
So-
but there is a direction to pay 15,000.
Lord.
This court reduce it to 10,000.
Lord.
If you are not even
Lord.
honoring that,
My lord,
we are recalling this order and directing to pay you 15,000.
my lord, last month, my lord,
And it's not that you are not getting anything.
Lord.
Your salary is around
my lord,
50.
he will pay regularly. My lord. I have
53,000.
instructed him, my lord, because his father was in hospital, my lord. So, my lord, he could not.
Therefore, why should you be in so much of stress and tension?
Right.
You will have to look after the VIPs in the airport, then your father, mother. So we'll ask the IG that don't give him tension, directly cut the salary and send into the account. Then one tension will be over. You can look after your parents.
No.
Isn't it?
Right.
You could not pay because your father was ill. Yes, everybody is having many problems in life. So one problem, what we will do is give it to your IG. IG will deposit directly to her account. We will be relieved from that anxiety every month.
And the case will be pending here, my lord.
Now, we'll decide it on next day. We'll decide
And if your lordship,
because
dispose of
already
the-
you have an interim order.
if your lordship dispose of the case next week, my lord, next day, my lord, then I think, my lord, this
We do
arrangement-
not know disposing of the date of next case. Otherwise, whatsoever it is an admitted position, she is your wife.
Right.
It is an admitted position, you have a child.
2 years
It-
old.
2 years old. It is an admitted position, you are a CISF employee. And it is also an admitted position that your salary is how much?
53,700.
53,000. You have some deduction. 15,000 has been given. Will not go beyond anything. No question of remand. These are admitted positions. Do you dispute any of these facts?
No, my lord,
No dispute. Forget about anything. That you are an employee of KS, you are having salary, she is your married wife, you have a child of 2 years, and the award is 15,000. And that too, this court has reduced to 10,000. This is also admit position. You have your old parents, their treatments are required. So he has not preferred a 50,000. We'll decide on the next date. In that meantime, we'll pass it. Or today itself.
I think
lordship may small matter, my lord, your lordship only 2 pages judgment, my lord.
What is this? What? Suppose we send it for remand. What is your case? Tell us.
My lord, she did not prove that she is, my lord. I have, my lord, driven her out, my lord. She filed 5 cases against me. Several complaints before the authority, my lord, against me.
Because of your
From the day of marriage, my lord. 498 case filed, final report submitted. Thereafter, again, same case filed. This one police stay.
that can be a very good ground for divorce, but not for maintenance.
Lord.
That
And
can be a good ground for
nowhere, my
maintenance.
lord, she
For divorce, we know that law. All cases filing itself is a cruel. And I think recently some Supreme Court judgment has also changed that. No, filing of cases and giving final report may not be cruel. There are two views now. So, in view of this admitted position,
here, my lord, only one day given by the family court, next day judgment pronounced. And that time, my lord,
court says it no necessity. All these are admitted facts.
this what my lord is saying. It has been stated by the court.
That is, I have
not
seen the
if
judgment.
that is so, my lord, there is no requirement or procedure, my lord. Wife will file the application and court will pass order without hearing
when
the
we-
husband.
Do you dispute that?
Lordship.
You file an affidavit here.
I'm not disputing the wife, children.
If you are not
But
disputing wife, you are
negligence,
not
my lord.
disputing
She
the
has to prove
children,
the
if you are
negligence,
not
my-
disputing your salary, then nothing to be decided in exercise of power under
125, my lord.
no power of this court.
482.
The first language, my lord, in
We will give
125
you a-
upon
we-
proof of
we-
negligence.
we will give you an
Lord.
audience
Lord.
on subject to deposit of how much amount due?
It was my lord,
10,000,
last
my lord.
10,000, but lower court directed from the date of filing. That has not been done. It was given on 8,000 last month. my lord. Although this honorable court directed to
So
pay
you
10,000.
may, my lord, arrange, my lord, area, my lord, I
Area-
give in installment, my lord, that you lordship may
Okay,
lordship.
so give your
Lord.
proposal of installment
Lord.
and we
And 10,000 he will
and
pay regularly, my
10,000
lord.
continuation,
Lord.
then we'll only give you audience. Please this matter on next
Lord.
Monday, have your instruction.
Lord.
What should be the installment? Please this matter again on Monday. You have your instruction, what installment will not pressurize you. She will also at least have something in addition to her current.
Well, so far, I don't know what 24 is concerned, my lord. I have examined the LCR. LCR has been received.
Ah.
But it consists of only some scissor list and my lord, charge sheet and my lord, copy of the FIR. The 161 statements are not there. Now, without going through the 161 statement, it will be difficult to arrive at a conclusion whether prima facie case has been made out or not. My lord.
Okay. Though the scan copies of LCR of PRC number 1707/2009
1704.
1704 of 2019 is received. However, the case diary, including the 161 statement recorded by the IO,
And
In-
some documentary evidence are also my lord, seized.
including the seized document in connection with PS case number
BIOPS case number 28, public 2018.
2018 has not been received. Registered to specifically call those copies, scan copies, and list this matter
On 14th.
on 14th of
Sep-
14th of September.
Public.
Well, your lordship. Here the petitioner was convicted under section 138 of NI. And thereafter he filed appeal and that was dismissed. And against those orders, the petitioner is for your lordship. Your lordship, the main
Why this matter is listed in order?
admission.
Admitted.
Here the main fact is that lordship, the petitioner through cross-examination of the witnesses was able to show lordship that the people show preponderance of probability that the complainant have no capacity to lend the money because lordship from during
Do you deny that you have put a signature?
no the signature was not denied but that check was because lordship they were together doing a business and that check was given to give salary to the other employees lordship. That check was misappropriated. And regarding that,
Have you lost any?
no, he came to know subsequently after receiving the notice. That
Did you reply to his notice that no, this check is not for this. This check was for salary. It is not due. Have you replied to his notice?
no, that was
Then-
not there. But even if your lordship see the evidence of that complainant, he nowhere says that from whom he has taken money. But for the past time during
Can
cross-examination,
it be a rebuttable presumption that since he is having no money, so he cannot he is not lending you the money, and therefore it's not an enforceable case. Is it law?
that aspect has to be considered. There-
Anything on this?
Yes,
by
our
Supreme Court?
our High Court judgment is also there. And
But it says
it said that that complainant have to prove that he has the capacity to lend the money if it is disputed.
in
And here,
138,
yes, Lord. If Lordship, here, Lordship, I have disputed that, and even from the his evidence,
anyway that will hear it.
Lordship.
My lord, concurrent finding, everything is clear.
Concurrent finding, but you want to argue will
Might.
give a chance. Today we will not be in a position to
Might.
hear, and we will be in a position to hear, but not a position to dictate
Okay.
the judgment.
Might.
That's why some other old matters are there.
That may be.
29. So 29 will you also know what is his argument? That
Right.
you did not have any capacity. Therefore, he raised the rebuttable presumption. Presumption was defeated. Now it was honor
think- yes.
shifted upon you. This is your
Yes.
case.
Might.
Honor shifted upon you that I had the capacity and I have. This is your case.
My case is that I have
Is-
to prove my case through preponderance of probability.
Probably. So you
So
have
not
I can
necessary at
take
the past
advantage from
instance.
his evidence also. Then
And because he did not answer my demand notice. Now
That is not mandatory.
he is
That you
putting a
argue,
question.
that was a question from this court. You
Okay.
argue that on the next day.
29
For admission,
Tuesday.
20.
in admission.
In admission, we'll decide it at admission.
Right.
Will not allow this to go to the hearing. Otherwise, we could have
Another aspect is also there, Lordship, just I'm taking more time, Lordship. Here, Lordship, if your Lordship turns to,
No, will not turn.
no, the legal issue is there, and regarding that legal issue, Lordship, there one case is also pending before this honorable court. And as I have been informed by senior counsel, Mr. J. Kamar, he has been appointed as amicus curiae. Same issue is here also, Lordship. That evidence was recorded by another magistrate and judgment was passed by the different magistrate.
So then,
Whether-
when then the process will be vitiated.
Supreme Court judgment is there, I am having that judgment.
So
also.
then we will not be able to transfer any magistrate
Yes.
during trial.
That judgment is also there because Lordship 326 subclause 3 of CRPC says. Because if it is summary trial, that
So now, give us an option. Suppose summary trial, how the magistrate. So we'll have to keep a magistrate for negotiable instrument in a place without transfer until and unless the matters are over.
that is what I understand, Lordship. Because Lordship,
We do not understand in
the
that.
Supreme Court judgment is there in that regard. The Supreme Court has remanded back the matter for face trial because of that reason.
So all magistrates having negotiable
And therefore
instrument will have
they-
to be stationed in a one place.
You have to conclude the trial.
That cannot be the law.
But because
And there will be some other judgment where we can distinction that this is not a ratio residency, this is an obiter. There are no problem on us dealing with that.
that issue is also there and
1975. Every fact of case
no, yeah.
changes the ratio.
But 326 is subclause.
We'll see it. We'll see it on that. Problem.
My lord, on last occasion, this is 14th August 23, this matter was heard at length by Honorable Mr. Justice, my lord, M.K. Kalita. This order, my lord.
Huh?
In the IA, my lord.
In the
299,
IA,
2000.
Yes.
In this case, my lord, I'm the complainant, my lord.
No, what you say extensively heard by this court?
No, my lord, Honorable Justice M.K. Kalita.
Honorable Justice.
Mridul Kumar Kalita. Honorable Justice.
Okay, now what?
The certain after hearing me, during course of hearing the interlocutory certain queries were posed by this court to which
But the learned judge has not said what are the
yeah,
queries.
exactly, my lord. They have to we have to start again, my lord, before this. In this case, lord,
What is the IA for?
I am, my lord. We have filed an application under section 302 for the complainant to substitute the legal heirs of respondent number 2. During pendency of the matter, my lord, the complainant he died, my lord.
Negotiable instrument.
Yes.
What is the law?
Yes, in my support, my lord, in my support, I'm relying one honorable apex court, one high court, and one of this honorable court, my lord.
It should be dot on negotiable instrument. Suppose a person dies.
Yes.
In case of negotiable instrument.
My lord, here in this case, my lord, on the last occasion, my lord, one question posed, my lord, at the appellate stage, whether this honorable high court has the power to impede to substitute the legal heirs or not, my lord. This question was posed on last occasion.
That is not a question.
Yes, and my lord, in this case, my lord, that NIH, my lord, the legal heirs is to be submitted or substituted or not. It is elaborately discussed in Kushal Kumar Talukdar, my lord, reported 2004 GLT 464, my lord. And another, my lord.
No. See, Mr. Deka.
Yes, my lord.
Don't rely on too many judgments. One judgment is enough if ratio is laid
Yes,
down.
my lord.
We don't have that much of luxury writing this judgment, that judgment. Come to point on dot.
And this case also High Court, my lord. Bombay High Court.
Yes.
Here the question is that the person died, the complainant died, he was unmarried, he has no legal issue. Now the IA has been filed by his brothers and sisters, old brothers and sisters, being pleaded and to continue. So in view of the judgment cited by my learned friend, of course, the legal heirs, they are the second category of legal heirs, not
If no class one, it will go definitely go to class two.
class.
Yes.
Of course. Now, question, my lord, is the matter, even if our appeal is, the revision is not allowed and it remains as it is, then it has to go back to the original code. And the legal heirs who are claiming to be the brothers and sisters, they're old people. So the trial court has to,
Why appellate court is not having the power?
no, your lawsuit, the appellate court has the power to
So
implement.
will
No,
substitute
it does, but because of the identity, whether they are so and so, because the original court itself has to ascertain these positions. By
or then in every cases we'll have to send it to the trial court for substitution. In your second
not substitution, I'm not, our dismissing of this revision petition mark for disbursement of the money or for direction to pay back the money, the complainant, sorry, the petitioner has to pay money to the legal heir of the deceased complainant. So their identification has to be ascertained by the magistrate.
that will be a future event. Now, whether we are having a power or not to implement the legal
As per CRPC, my learned friend showing the 302 CRPC that there is no clear specification mentioned in this particular section that the legal heirs are entitled to be impleted. If I throw your lawsuit at
there are some exceptions, more particularly suppose in a defamation case. The person who files the defamation suit in a civil case dies, the legal heir will have no right to contest. Is there a specific provision? What is the 30? Identification, it is later on. Who did detain us so much? Mr. Chaudhary, PM Chaudhary. The negotiable instrument against conviction and compensation.
Yes.
Now, the person complainant dies, his legal heirs have come to substitute. I think they have a right, isn't it? Or they will not have.
I think so, but legal provision as per 302.
302. We have to do something different.
Section is for mainly for trial.
Try it.
So the question
Any
the other day
minister
was
will
posed by learned Honorable Justice.
Don't take the name of this court. We are court, not by name. What is that provision where the victim can appeal against acquittal? There is a provision. Huh? No, 15 can appeal. Suppose there is an appeal against acquittal. The informant dies. Whether appeal will abate or the other person can come and join as an appellant.
Only
No,
date of the
no. But otherwise, we'll suppose that a person is acquitted. The informant has come, not the victim. Informant has come. The informant dies in the meantime. The appellant dies. Now, what is the procedure? I think we passed the judgment sitting in a division where Mr. Talukdar was there, Depository Talukdar. That it is to be imputed because we want to know the exact proposition. Yes, Mr. Dutta. Yes, what is this? No, suppose in a negotiable instrument case, suppose what this judgment says 302.
Supreme Court. My lord, this is the Honorable Apex Court. Judgment.
If we go by this law, Kushal Kumar Talukdar, in no ambiguity, court has said that in a case of complaint under section 132, 38 or 142, if the complainant dies, his legal heir will have a right and magistrate will have to his son substituting his substitution of a complainant on his death permissible to in exercise of power under section 302 as there is no provision of substitution. If that be so, why not under 482? Decision 482. Got some judgment in case of specifically on Supreme Court judgment. Which one you want?
My lord, I am relying the Chand Devi Dagda, year 2017 Supreme Court 5126 and another from Bombay High Court.
But Bombay High
Oh,
Court.
NI on procedure to
No, this is Supreme Court is NIF or something else.
not NI, my lord, enough for the complainant title 424. These are other section, my lord, but Honorable High Court is allowed the legal heirs. Same was challenged before the Apex Court. Apex Court held High Court is correct, allowing the legal heirs to substitute.
Here issue is basically in a case of 138 and 142.
This is a Bombay High Court order, my lord,
Even-
on NI.
What is the ratio paragraph of this 2004? Paragraph,
Yes, my lord.
the reason and ratio laid down. Which paragraph?
Hmm? Yeah, right. Well, 52, 53, 54. Mainly from 50 milot, it starts.
In terms of this judgment, we can allow your petition, but we want to doubly assure and verify what is the law in this regard in Supreme Court. We can allow his petition on the basis of the ratio at paragraph 54. And we'll simply say that we agree with it. And but what a Supreme Court said that we want. 256.
My lord, CRPC, my lord,
Mm.
section 2WA, definition, victim.
That is what just a few minutes back I was 2WA.
Yes.
Okay. Yes. That is that. Why should you go to 302? Why should you go to 302? This is definition. Nothing more is required. And there are some judgment come at 12 dictate disorder. There are some judgment we pass interpreting this. Division bench with my lord just jump. Okay,
At 2, my lord.
we'll pass this order.
At 2, my lord. Oblige me.
Make the 482 application, my lord. And one FIR was lost, my lord. There is a lab affair between the informant and the my lord, main accused. And my lord, subsequent when FIR was filed, I got arrested.
I am for the respondent number 2, my
Oyo.
lord, informant, my lord.
Not Oyo, they are student, my lord.
No, Oyo,
Maybe, my lord. Maybe, my lord.
Oyo and Hatigam.
Oyo and Hatigam.
Yes,
Yes, my lord, already, my lord, settled the matter, my lord, and yes, now
Let
I am, my lord,
let it be on record, my lord.
that
In
is
case,
that-
I don't want, my lord.
yes, only an affidavit.
But let it
You
be on
file an
I will file
affidavit.
a affidavit, my
You
lord,
file an
File-
affidavit,
within 2 days, my lord.
but
So in that interim, my lord, that may be stayed. As because he has declared. He has declared.
okay. You file an
Yes, I am
affidavit.
within 2 days, my
The present application is filed under section 482 because we'll have to in this type of cases
yes.
ultimately 376 and all are
Yes,
there.
yes.
But from the facts, it's clear that it continued for years.
My lord,
Once abortion,
my lord,
then also thereafter it continued.
my lord. And so far, my lord, the charge sheet says, my lord, so far the pregnancy part is concerned, my lord, no evidence.
No evidence. No evidence.
So that's why let her file an
So therefore, any scan copies has
Yes.
come.
yes, my lord.
Come. So we'll have to rely on the scan copy. Also.
Right.
We cannot straight away pass this order.
Yes, yes, that's
So
fine.
the offense is a serious.
Yes, but that's why, my
So
lord.
that's why your
Yes,
affidavit
I will
is
file, my lord.
the learned
Day after tomorrow.
counsel for the respondent has entered appearance and prays that he may be allowed to file an affidavit. Full stop. The present case is filed under section 482 for quashment of the proceedings in view of the settlement and compromise entered into between the petitioner and the respondent number 2. Full stop. The learned counsel for the respondent number 2 submits that submit that they have in fact uh, compromised the dispute between them, as the FIR was lost out of some misunderstanding, as both the petitioner number 1 and 2 were having a long-standing relation. In that view of the matter, the this petition be listed again on 25th of September 2023. In the meantime, the further investigation or search or proceeding
My lord, proceeding pending before Chief Judicial Magistrate
Corpeta being
being PRC number 1509/20
self remain
and deeply obliged.
to file an
Obligement.
affidavit
Obligement,
detail
I file this.
and
They have
file
to-
an
right,
affidavit. Otherwise,
Yes, ma'am.
I'm obliged.
Obligement.
In this hearing item, my lord, item number 52, I may be granted some time for preparation of this application.
on 1/8/2023, a prayer was made and we adjourn it till 22.
Yes.
And if we're not prepared, take your seat. We get ourselves prepared.
At two, my lord. At two, I will complete my argument.
Okay, you have to, you do. In the meantime, let us have this. Any paper book? No.
Answer is here, paper book is there, but I have flag marked the PWC and all this.
We'll come back at 2. Let us, in the meantime, not waste the time. And what is the next paper? Huh? Old paper.
Yes, this is 2009. Conviction is 1 year. 13(2) of the PCI.
I may be allowed to bring my file from court to another court. Yes?
Okay, at 2.
Well,
Sir, even
I'm
without the
sorry, my
file,
lord.
at 2. Better be sorry. We feel ourselves sorry. Looking at the state of affairs. Yes, item number 53. Adjournment.
This matter, please, this from it has come from another chamber. So I have also recently got the file and I want to pay some judgment also. Actually, I'm not fully ready to do the matter.
2012.
That I did. Thought it was okay.
Hopefully by 1 we will be.
No, Mr. VM today is there ready to do the hearing.
We may not hear BM to this case. This case is of 20. Huh? 2005. Then we will get. What are the offenses?
304, it is a conviction and then 7 years imprisonment.
304.
4 7 years. Earlier, he was in custody for the last 10 months. So judgment will be required.
Under star on our system. Nowadays it blinks in the system. The MIS system it blinks. Guwahati High Court is having 2012 pending cases. It will blink and it will be reflected to the adjourned. Infrastructure.
Well, my 50 holiday, 15.
Yes, what happened to Abdul Samad?
This is appeal against acquittal, man.
Appeal against acquittal.
There are 3 cases were there, my lord. We filed this appeal against acquittal, another for enhancement against the, my lord, conviction.
So one by you, both by you,
2 by me,
two by you.
one against the, my lord, acquittal.
Yes,
one
Mahmood.
I'm only in 1954, man, for the 3 accused persons.
Ah.
The student number 2, 3, and 4.
Okay. What was the offense alleged?
They were acquitted of the charges 324, 326, 307 by 34 IPC.
Okay.
Here, my lord,
What is the ground for acquittal?
injured witness, my lord, though he has been believed, my lord, it was taken by the trial court that his evidence has not been corroborated.
Medical evidence was there.
Yes, medical is
And
also-
medical corroborated the injured witnesses evidence.
Yes.
What more is required? Mahmood,
My lord, kindly see page 29.
we'll see. These are the preliminary for hearing.
Yes. My lord,
Mr. Chaudhary says injured witness examined. Injured witness is the
Best.
what we use best witness.
but here it is, my lord, the PWS also did not see the accused person at the place of occurrence.
No, we do not require any eyewitness. A person who was, suppose Mahmood is beaten up in front of High Court.
Yes.
Okay. Then there are injuries. He was taken to MMC.
There-
And Mahmood says that there is a car mark here. He beat me here. Doctor says yes. These are the injured. And there are some other people like Mr. Goswami, they do not like Mahmood. So they say, no, we have not seen it. We have seen some quarrel, but fighting we have not. Which to be believed? Injury, the statement of the injured victim and the medical report. This is my concept in
Yes,
case of 325. I do not know.
But the injured person's evidences are not credible. And they are full of suspicions and
Was there any injury report?
injury report.
Was that injury report proved? Did the doctor report that this man was taken by so and so in connection with so and so case?
Injury reports are there, my lord, from PW 6. But the prosecution could not prove that these injuries were caused by this 3 parts. The learned judge came to
So the injured person has not named you.
But actually,
You are not ready.
ready means evidences copy are not furnished. And a long
Who will furnish the evidence?
So 2013 case, my lord. So
Mr.
I'm otherwise ready, but I'm not saying what it is. Say, I can use the copy data short that day, I will go through it.
Since-
But
since
there is a clear finding that the prosecution could not establish the charges against these three persons beyond reasonable doubt. And there is
See,
no,
see, two things will remind ourselves. It's an acquittal.
Yes.
If there are two views also possible,
yes,
we may not take the, we'll go by the trial court. But
Yes.
at the same time, if the witnesses are there that so and so has beaten me up by a rod in my head, I got a head injury in the left side of my skull. And the doctor says, yes, on the same date, this person was produced by Habildar number so and so, so and so. In connection with so and so case, I examined him. This was his injury. This is the injury report. And his evidence in cross-examination remained unshaken.
Yeah. That is the main thing.
Then we'll say it will be a perverse decision.
Yeah. History, stating history before doctor.
So it's not necessary that there must be some eyewitness, or that presumption is not presumption that it is rebutted, so nothing happened.
But it is
Any eyewitness, Mr.
Yes, Mala, there is another, his father was also there, he was also in
Okay,
PW1.
he is also a witness.
He is PW1.
PW1.
The appellant in this case.
Appellant is this case is a PW1. And who was the other injured?
PW3 is the injured, his son.
His son.
Son.
And any other person?
His wife and my lord, informant's wife and daughter, they also immediately came to the place of occurrence.
And they found them
In the
lying.
place of occurrence, they have seen some of the accused going away from the place of occurrence. Court has also come to
So according to you, it will be that it is established beyond reasonable doubt that he had injury.
Yes.
That
also led to
injuries,
6 injuries.
6 injuries corroborated by the medical evidence. And it is also established by 2 PW1 and PW3 that it is none other than Mahmood's client who has inflicted the
And another accused who was convicted, but he died already.
one another who was convicted. Now other evidence will be that they were also seen in the place of occurrence at that point of time.
Yes.
Any eyewitness fighting or beating?
Because this injured witness and his
No,
father,
except it.
other
Any
witness-
other witness
No.
present in that vicinity or something, nothing, no.
no,
Then what was the
some
ground?
immediately,
What was the ground of acquittal of these two persons?
mainly because my lord, that it has not been corroborated by the other witness. May I
What
read?
corroboration? Do you need an eyewitness?
Yes, at PW3's version, court has come to a finding that, may I read it just there?
Yes, yes.
Para.
But will give time to Mahmood because his client has already been acquitted.
Yes.
If we
yes,
take a different view, we'll have
Case
to
of 2013 May.
that certain cases will, because these are preliminary thinking.
my lord,
Even if there is two possible views, the
That
views
is also there.
favorable,
If two possible, generally in a
yes.
case of acquittal, we will be reluctant. We will doubly see that
Yes.
whether case is made.
Yes.
So be prepared. But as a whole, what Mr. Chaudhary has submitted, we think he might have been able to make out a case.
Okay. Injured person.
Give the copies to him. Those 3 matters are gone. When? 18. How much? The hearing list we have taken. Then what would have been? So that on that day, they don't. any other that we slowly will come with whole painting. 89 Mahmud.
Originally case of my lord,
No, no, whatsoever case,
98.
so we'll have to finish it off.
Yes. That
Mr. Mahmud and come place for some accommodation as he has placed
no, not provided. And they,
who will provide you?
this,
You will be provided with the only
yes,
appeal memo.
they have only provided this copy without.
That much only will be provided. You'll have to go to the record. Who has
Yes.
told?
Yes, no, my learned friend has already
No,
helped me.
that is his magnanimity giving it. But
Yes, yes.
evidence
I
he will give
admit,
you.
I admit.
If you have separate set, give it us also.
And they have given a number.
Photocopy and I'll provide.
Then we can go serially along with you. People, according to the Cholpuri submitted, can furnish a copy of the evidence, etc. to Mr. Mahmud. In view of the profit, the matter that adjourned to the whole pending matter and be listed for hearing on 89 page.
18
21. What is the urgency?
Mr. Bhattakur had appeared on the last date, my lord. He said he was not declared. He was requested to, my lord, go to this. My lord, your lord,
What is this?
in a
What about?
motor accident appeal, my lord, claims appeal, claim case, my lord. The court, the learned member disbelieved the claimant's case that the vehicle, that the deceased was hit by an unknown truck. And
That
collision was, my lord, suspected. So there was a direction to file an Azahar. In that Azahar, I was the final IO, my lord, who had filed the charge sheet. I had come at a later stage, my lord. And my entry was at a stage, my lord, when the actual vehicle, my lord, the Maruti car, that was found out, my lord. It was not a truck, a driver, and his deposition I had taken, and thereafter I filed the charge sheet. And thereafter the case proceeded. And then the claimant, my lord, the victim, that they filed the claim case. But in that case, my lord, the learned member said that they suspected.
Manipulated case. No,
Yes,
no actual accident.
yes.
Yes, what about?
Yes, my lord, I have gone for the LCR. I have also flag mark from the, my lord, relevant to regarding the present case, my lord. Later on the basis of the FIR of the, my lord, insurance company, that CIDPS case number 4 of 2015 registered. And in regarding that case, my lord, probably search sheet not yet submitted regarding the present case. And my lord, initially, my lord, here accident occurred on 23/9/2006. And my lord, on that day, on the basis of one GD entry, my lord, one.
DBN3 is on the basis of maybe somebody's phone call.
Yes,
Yes.
on the basis of somebody's phone call.
Phone
my
call
lord.
that a truck.
Yes, everywhere unknown truck, my lord. Initially, one IO, my lord, Bruno Bora, first, my lord. Thereafter, my lord, although my lord, incident occurred on 23/9/2006, FIR, my lord, thereafter, my lord, registered on 5/10/2006. Thereafter, my lord, one another, my lord, IO, Omilya Kumar Nath. Thereafter, my lord, the present, my lord, accused person, my lord, he takes over the charge of the case on 29/10/2007, and from the record it reveals that, my lord, since then, my lord, till then, my lord, that vehicle which was involved at unknown truck. Later on, my lord, after taking charge of the present, my lord, investigation by the present accused, my lord, my lord, one, my lord, Maruti vehicle was, my lord, in place of, my lord, unknown truck. One new Maruti vehicle.
How that was identified? What
My,
the CP says?
my lord,
There must be some explanation. That though it was unknown truck, during investigation I found that it was not a truck. It was a Maruti car. Then he tracked it and got the owner of that car Now, what is the owner statement
My
of the
lord,
owner
here
of the?
the owner of the, my lord, the statement is not available regarding the Maruti vehicle. Probably one driver, Moinul Haq,
Hmm.
his statement is available. I have flag marked that, my lord.
He had admitted, my lord, at
but-
page 18, my lord. in
And
my-
while, my lord,
So
regarding
his
investigation,
finding of investigation is based on some material.
regarding the present case, my lord, investigation, the last portion of the LCR is available, and the present accused person also interrogated, my lord. Why, how, my lord, in the entire case, there is, my lord,
It was-
initially
what is his
unknown
explanation?
unknown truck.
What is his explanation?
And, my lord, only within a single day, my lord, on 29/10/2007, that is, my lord, reflected from the LCR.
Hmm.
On the same day, my lord, after taking over charge, my lord, he has filed charge sheet on the same day, on 29/10/2007.
When he identified that it's a Maruti car.
My lord, same day, probably in a Naka checking, my lord, probably one Maruti vehicle found. Thereafter, my lord, he said that, my lord, this Maruti vehicle is involved.
And who is the other bringing that vehicle? Anything on record?
On that statement is also well available. My lord, there is
Who is the person that
some
brought this Maruti car? That
Yes.
also we'll have to see.
Yes, well, it is, my lord, reflected in the, my lord, investigation of the present case, last portion of the LCR.
What
my
it says,
lord. I have flag mark, my lord.
that is what? What is
Uh,
that? This is
yes, LCR, no, my lord, LCR, LCR, account, no, LCR, account.
what is this GR case 114906? State versus Moinul Haq. Any stay?
No, no. That is Dhula PS case number 127 of 2006.
My lord, initially it was a Maruti, it was my lord, Maruti vehicle, then probably this person would have get some compensation, my lord. Otherwise, my lord, last portion of the investigation, this Maruti vehicle, my lord, came to light. My lord. Otherwise, there is no doubt that one accident occurred and, my lord, one person died.
One accident.
Because compensation was rejected
What?
because
What was the earlier compensation? Suppose we say that no, it's correctly held to be a Maruti car. We cannot find fault.
in that case, my lord, then claimant will
Then again it will be now tell us how the other earlier IO on whose statement it was decided. It was decided that it is a truck.
Because, my lord, IO has stated that initially, my lord,
Any eyewitness?
yes, one injured eyewitness along with the, my lord, this person, he has PW2, my lord. He has stated that in that case, my lord, one Maruti vehicle regarding Maruti
The
vehicle.
eyewitnesses.
Eyewitnesses, he stated that on that, because, my lord, on that basis,
No, first thing first, the proceedings started with a GD entry.
GDN,
Over telephone that some person has been hit and run by an unknown truck.
unknown truck
This is how the investigation started.
started. My lord.
Now, in the accident, somebody died.
Yes,
One died, one injured.
one injured.
Now, forget about him. The earlier IO was this who he recorded a statement of this injured and injured at least.
Yes.
What was his statement before the earlier IO?
Before the, because he supported the case of the claimant, because claimant,
Forget about because we will come later on.
yes,
Before entering,
unknown truck, my lord, unknown truck.
the injured person's statement was what was the statement of the
Initially,
injured
I
person?
will have to again check the.
When the statement was taken?
Yes, at that
That
point.
is a vital issue.
Yes, yes,
Because at that point of time, he was not there.
not there.
And suppose the earlier IO has not taken the statement of the eyewitness, and the eyewitness subsequently states it is a Maruti car, it's a Maruti car.
Yes, well, subsequently, he has in that case, my lord,
Whatsoever, suppose
Yes.
an investigating officer
Yes.
has not examined or recorded statement of an injured victim.
injured.
For criminal case, at least
Criminal.
forget about MSCP.
Hmm.
Injured victim. And subsequently, during investigation, another officer recorded is the injured witness. He said it's a Maruti.
Maruti.
Whom will you believe? No statement and statement. And GD entry over telephone that one truck. Because we will have to go by the record, not by the fact that on the day he has submitted service, might have some negotiations, but we'll have to see the statement of the injured. Otherwise, if we say no, that cannot be, then in many cases this will be a problem. Even injured victim statement will not be believed.
Because
It will have a double-edged sword.
in the proceeding of the claim case, PW2 stated he supported while supporting the case of the claimant that it was a Maruti vehicle which was involved in the accident.
And what is a 161 statement during investigation? Because this is an criminal case.
Yes.
Rash and negligent driving of 304 but
One-
part 2 304 A. So while doing the investigation in 304A, what are the statements of the eyewitness? That is first vital thing.
First one.
If there were no eyewitnesses, we have heard that a truck, that's one part. And if somebody says it is a Maruti car, and if he could identify the Maruti car by his sharp brain, what you say, Mr. Das? And even the driver admits, what more you require? Cannot proceed again. So go to it. No. Some other day. What was flag market?
And probably 161 statement earlier he stated that it was an unknown truck.
So as that.
Yes.
So there are
That IO is no longer there, my lord. The earlier IO is no longer there.
certain state dates will be very vital.
Yes.
How the investigation started? Number one. And what was the information? That GD is the GD entry is there. That I proceed on the basis of a telephone that an accident took place in so I proceed. He proceeded. He will do something. I seize the vehicle. I have recorded statement of nearby people. Then there was an injured person. Injured person was taken to hospital. It's an vital and essential to record his statement. What is his statement at that point of time? And subsequently, suppose if his statement at that point of time is a Maruti car, it's a Maruti car. If his statement is unknown or I have not seen, subsequently Maruti car, that we made out, then maybe near the requirement of investigation.
Exactly.
So these are the important vital issues you flag market.
Yes.
And when he entered, these dates are very important.
Yes.
So these records have been here for quite some time, my lord. Adjournments have been taken. And in the meantime, I have also been promoted, my lord, and I am in 2 years' time I will be retiring. So if it better can be disposed of at an
I early not today. I want to go through this record and I want help from Botako.
Yes.
These are the vital issues.
Yes.
Huh?
Can it be kept to the partner?
I think I'm here for quite some time. It seems.
Early date, my lord, may I please?
Yes, even early date. Huh? 15th of September.
Yes.
Botako, just look into
Yes,
that.
I will go.
That is what we'll see.
I will point out, my lord.
Yes.
Before the IO, my statement has been recorded. FIR, your lordship will find at page 48.
Yes.
So my name is appearing, but the specific allegations is not there. This is to inform you that today's specific information has been received from a reliable source stating that a group of people, out of which 2 persons from Tinsukia, Sri Ram Prasad Sai and Joypal, I am Joypal, and another one from Sibsagar, namely Kanaya Mandal, indulged in criminal conspiracy of cheating, misappropriation of money by making false documents and using false document as genuine in lieu of receiving a vehicle on hire by Oil Natural Gas Corporation Company, and the group offered high rate of hired value, and they collected huge amount of rupees from interest
interested persons for obtaining the work order using backdoor practice. Further, the information revealed that a group collected money in a HDFC bank account of Sri Kanai Mandal, and one accused, Sri Rampasad Shah, is supposed to meet a victim at Hizuguri for collection of money and discussion regarding work order for two vehicles supposed to be absorbed in ONGC. Accordingly, information was shared to IC Hizuguri TOP and able to apprehend the below noted accused person and recover rupees 4,72,000 and odd, along with other incriminating materials from the possession consequence of his house search. Further, the bank account of Sri Kanai Mandal has already been freezed and there is huge amount accessed in the account. So here the allegation is that the vehicle to be deployed in the ONGC and for
Are you promise that we will give you contract?
Yes.
Give us money, your
Money.
truck will be or whatever.
Yes.
This is the motor.
Hmm.
And this idiot informant, they gave them money.
Hmm.
That's the case.
Otherwise, my lord, regarding earlier, the
Same like gold port,
yes.
gold piece. Every day it is
Otherwise, my lord,
all need shortcut money, not only him, the others also who are having the truck.
Here, the thing is, I have been a victim, my lord. I am a victim of these circumstances, my lord. In fact, this Kanai Mandal is an employee of ONGC. So far as vehicle are concerned, he is doing this racket, police also on that, my lord. But he treated me for giving me a job. He has given me a appointment letter as well as joining report, and thereby accepted.
My lord,
And
no, my
thereby
lord.
accepted
I will point out, your lordship.
17 lakhs and odd money from my from me, my lord. Some of the bank statement I have, my lord, annexed.
And what about this Kanaya?
My lord, regarding the present
Kanai has
accused
been
person, Kanai
initially
Mandal,
arrested, and therefore, my lord, he has been granted bail. One of the ground in the grant of bail is that from the case that it appears that the petitioner even later on returned money to some other persons. The petitioner Kanai Mandal stated before police that he has returned money to some of the persons who expected that their vehicle to be used by ONGC. He is the person, my lord, he is returning the money.
my lord, my lord, here in this case, petitioner obtained interim on 11/7. My lord, although my lord, CD is up to 27/6, I confirmed from the IO, my lord, he appeared before the IO, statement recorded, my lord, although CD is up to 27/6. Regarding the materials, my lord, he is a victimized person along, my lord, he also paid that amount of money to Kanai Mandal. That is not, my lord, true, my lord. He, along with my lord, Kanai Mandal, involved in all these, my lord, racket, my lord. And there are, my lord, there are many other affairs, although some of the affairs were not registered in, my lord, police has treated them as additional information, my lord. And my lord, many other individual person has, my lord, lost affairs, my lord, against the present my lord, present accused persons also, how he has, my lord, collected money from those persons, and thereafter, along with, my lord, and there is a, my lord, bank account of Kanai Mandal, SDFC bank account, all money transaction, my lord, takes place to that account, my lord.
It is the bribe giver are also there.
So-
Yesterday or day before yesterday, we saw that Mr. Das was there, I think, through Google Pay.
Yes.
Bribe paid through Google Pay.
So, my lord, it is not a fact that, my lord, he is a victimized person, my lord. He, along with Kanai Mandal, Ram Prasad, all are involved in this racket.
So, his friend stayed for some days.
Yes,
Inside.
he already, and now he is seeking
Now
for
let him be
anticipatory bail.
there for some
So, my lord, my prayer before your lordship, at least, my lord, yes, the complainants who has paid, they are also, my lord, your lordship has already, my lord, the idiot, yes, my lord, they true, my lord, they are also. Why they must first inquire, my lord, while
Who
they are
is
going
he?
to pay huge amount of money, my lord. First, my lord, being a literate person, first they will have to inquire from the ONGC why they are paying this money to these private persons, my lord. In fact, Kanai Mandal is not an employee of, my lord, ONGC, my lord. All are, my lord, he is earlier working in a private hospital as a my lord, assistant, my lord. And thereafter, from that, my lord, hospital, my lord, he was kicked out. And thereafter, my lord, he has also, my lord, on the pretext of providing job, my lord, to that, my lord, nursing home, my lord. He also, my lord, taken some part of providing some back appointment. There is statement of that, my lord, earlier nursing was also, my lord, last person available, my lord. That last portion of this video. And, my lord, regarding some affairs, a specific allegation against Joy Pal, that is also
My lord, you can find my lord, the annexure C only, my lord, it's my bank statement.
The bank statement is also available here.
Page 16, my lord. The last entry, my lord, you find, my lord, 16/26/8/2022 to Kanai Mandal, 1,50,000. The next page.
You're sharing the amount. You
No.
have taken some from someone to
No,
relax, give 1.5 to Kanaya.
no, this, my lord, the credit side, you also will find hardly there is any, my lord, big amount, my lord. Hardly, my lord. Well, he basically, my lord, runs a, my lord, a small, my lord, shop, my lord. And, my lord, looking for a, my lord, job opportunity. Thereby, he has to, my lord, be, my lord, in it. I am cooperating with the, my lord, police now. My statement has been recorded. Anything is required, those are all, my lord, materials on record, my lord.
This is the statement of one Rinku Muni Bora earlier, wherein my lord the Kanai Mandal was engaged. My lord. Has been.
You have to reject that. Which is upon that.
Okay, he was also one of the because his FIR also in the part, my lord, case. He is also one victimized person upon that. There are many other victimized person. First person of the case there is the middle person. My
So my, the story what I'm, submitted before lawsuit, that will, my lord, reveal, my lord, another record run by that, my lord, Kanai Mandal regarding job.
He said a work order.
Yes, work
Yes,
order.
click mark.
Yes.
So these signatures are forced.
No, regarding that, my lord, already that is not specifically written in the FIR. Regarding that, investigation is
But
going
they
on.
have said this.
Already ONC, my lord, that requisition sent to the ONC regarding that written report, that those are fact till now. Regarding that written report is not available. But from prima facie, my lord,
Prima
it's,
facie, the
those are fact, my lord.
record itself.
Yes.
Statements have already been recorded. Civil interrogation, my lord, whether that will be appropriate.
Because my
My
lord,
lord, the statement would have revealed, my lord, what
My view is a little bit different. If your statement is recorded, that cannot always be a ground.
it's true, it's true. But then what
Then there will be no meaning of passing any final order.
yes.
Interim, go get your statement record and police will proceed. That's not. Why should we fix for a case that is giving interim? Interim we give prima facie looking at the material. So that suppose in the event you are actually not involved,
Yes, yes.
you are unnecessarily not arrested. But after CD, if you think that your involvement is serious, his privilege you should not get. Yes, results is
The statement, my lord, of the bank account, my lord,
bank account we understand, but so many people
Yes.
have stated your name and his name.
Mm,
Those documents will seize from these people the work order
Yes.
and money transferred to Kanaya.
And,
Yes, may not be money transferred to Kanaya,
and
but it will not necessarily because if many people have taken your name too.
the-
That is the difficulty. Even if money has not, because the Kanaya, maybe Kanaya's account.
money has not been received by me. Because
Huh?
rather, my lord, from my account, my lord, independently, I have given more 17 lakhs because of this job. The appointment letter, my lord, that your lordship will see, that is also appears to be a fake one. But then he had to believe it.
Your appointment letter is not on record.
No, my lord, I have given on the, my lord,
That might have manufactured by
Yes,
you again,
yes, yes.
like these documents manufactured, because you have been implicated by not a single, not only one person, many other persons.
And my lord, in many cases, my lord, I have seen against one accused person laws FIR against another accused person, and behind them, my lord, there
There
are
are sufficient materials. We'll say that only, not that,
yes,
not more than that. But Peru, the case there is produced. The materials so far collected by the investigating authority clearly reveals the direct involvement of the petitioner
yes,
and one
Right.
Kanaya
Kanaya Mandal.
Mondal.
Initially, Ram Prasad Shah
The-
was in
The alleged fake work order has also been received and received. Nothing is found whether a dose has been sent for any forensic report or not. Therefore, considering the aforesaid fact that is the alleged involvement of the petitioner and the stage of investigation, its court is of the view that it's not a fit case to grant the privilege of pre-arrest bail.
Mm.
Accordingly, the present bail application that is with earlier interim order vacated is the IDP. Like,
47.
yes, whatever.
But
what
yes,
is
my
this?
lord, 47, my lord, right now, that, my lord, that case is now transferred to my Jalukbari PS.
Ah.
Jalukbari PS case number 34123.
Okay, now what is your grievance, Mr. Mr. What is your name?
Vikas Bucha.
Yes, what is
My
your
lord, I want to just stress this FIR,
was which affair?
710.
Space. Is 32.
Is
Yes, my lord, 32.
32.
That was initially lodged before Nagaon police station, probably, my lord, later on transferred to Paltan.
My lord, on which date this case was forwarded from Paltan Bazar police station to Jalukbadi police station? On 15 March 2023, this court has issued notice for submission of case diary. The investigating officer, whether not submitting the case diary to this court and transfer to another police station.
That they can do. See. Quashing of an FIR, first of all, those cannot be a ground for quashing of FIR. First thing first, whether a case is made out against the accused. I'm not saying you, in any case. Suppose we take it to be, everything is to be correct. Whether case is made out. If no case is made out, we will not go and do detailed probing and checking and now, for our satisfaction, we call for the case diary so that we can understand what are the statements and to assist ourselves in reaching a just decision. Now, therefore, let us see which was the FIR first, which you want to get it first.
My lord, the FIR was filed on 28 May 2021 before Nagaon Sadar Police Station.
Okay, that is page 32.
That is page number 29.
29 is the page, but relevant portion is that page 32.
Accordingly, the same FIR to Paltan Bazaar Police Station, and then after it will.
Let us first, what is the content?
Yes,
Who
yes.
is the informant here? Your wife? Or what?
My lord, it is
No.
one Pramod Boda, respondent number 2.
Purchaser, the intending purchaser.
Yes, what is your case?
My lord, in this FIR, Mr. Pramod Boda said that he entered into an agreement, right? Registered agreement number 6861/2011, and the agreement is registered between Pramod Boda and one Ashirwad Construction Company Private Limited, represented by Ravindranath Sharma. They made transactions. I don't know what is the transaction. Not. We come to know in 2019.
How you are related to this?
Yeah, I have business transactions with him. We have supplied construction material. Even today, I owe a very handsome amount of money from this Ravindranath Sharma. He given me checks. But after writing some letters and registration of this FIR, he was died. And all my money was in vain. My lord,
What is your business?
I am my lord construction.
Are you a part of this development?
No, no, my lord. I have supplied construction materials, cement, roads.
Let the investigation continue.
My lord, let me complete, my lord, because there are something. So this Ravindranath Sharma paid 10 lakhs rupees checks in 36 post-dated checks in 2021 to me. He written a handwritten letter in which he has said this our old outstandings. Now he has retired, his business has been closed, almost closed.
Rabindra Sharma.
Ravindranath Sharma, the person on who, the basis of whose letter, my lord, the page number 30, ekdam last line, letter dated 7/4/2021. This fellow, Ravindranath Sharma, because I won't get the opportunity to talk to this person, that you have given me checks in the month of February, post-dated check, that whatever the outstanding you have with me, I will clear it part by
The
part.
builder.
Yes, he was the builder. My lord, this was a very old outstanding. After 4 years of chasing, we got it.
There is the concern of the informant promoter Bora is that you have withdrawn the amount, entire refundable amount payable to her. That is the specifically.
Yes.
Sir, now point page number 35. Please go through, my lord. This is an information submitted before Income Tax Department under Benami Transactions Informant Reward Scheme 2018. I, along with one Mr. Hemanta Devri, specifically submitted that these properties are invested by one ex-MLA in the name of fictitious entities. This is a criminal conspiracy because I have filed one vigilance complaint against Dr. Durlabh Samoa before Director Vigilance and Anti-Corruption. And this matter is been presently under before this court in a writ matter is going on. My lord, this fellow, Dr. Durlabh Samoa, was trying to put pressure under me by hook or by crook. Some way or somehow he comes to know that I owe money from one Ravindranath Sharma, and Ravindranath Sharma has agreed to pay, but he won't want to pay. How these things happens in the market. So he entered with a conspiracy that, okay, you give me a written letter. What is the content of the letter? My lord, FIR. I will read down, my lord. That from the very day of booking the flat, above named Sri Vikas Muchal was introduced to me as co-developer. My lord, please go through the records of Messrs. Ashirwad Construction Company Private Limited. Any of the document can be
Where
signed
is
by
the
me, whether
agreement?
even a
Where-
single rupees transactions. will
Where
be-
is the agreement between the lady and the developer?
There is no lady, my lord.
That is who is the informant?
This Pramod Bora.
Okay. What is the where is the agreement between Pramod Bora and the developer?
That is in the custody of the police
Therefore,
officer.
investigation
Yes,
is
my lord,
required.
yes.
My lord, problem is that I have approached, there is no investigation and there is no case diary. Everybody knows, the police officer also knows that. There is a tendency, my lord, please go through the page number 52, the FIR filed before Panbazar police station. They have completed the investigation. They have called the flat owners, everybody. Nobody says that Vikas Bucha has taken even a single rupee from anybody. Even the director, other director, she is still living. She has recorded a statement that I don't know anything, whatever the transactions. Not even a single money receipt. This is the transactions about from 2011 to
What about this
2023.
Panbazar police station case?
My lord, regarding that Panbazar police station case, already, my lord, that is FR submitted, my lord, in that case, my lord. And whether
In this case also there may be FR.
My lord, how many days I will be sufferers? Because sometime
Hello.
after 6 months, police officer called Apunar against the case.
What is the suffering? Tell us.
My lord, police officer called Apunar Saturday evening. On the second Saturday evening, Apunar Thana Tahiba Lagibo. This is 4 years has
Yes,
been there.
Protocol.
Why the case
My lord.
diary has not been produced before the court?
my lord, otherwise, my lord, why under what circumstances final report submitted in Panbazar case, my lord, in that is a, my lord, I'm not going
We are
into
not
that.
on that.
But
That is
here
the-
there is a specific allegation that while at that point of time, he introduced himself as a
So
co-developer.
let us have see the 161
Yes,
statement of
my
the
lord.
lady.
And
and
now,
this
my lord, he is stating all these things, my lord, that my lord.
Those are irrelevant because he's not a lawyer. That's why he's arguing.
Yes, my lord.
So
Otherwise,
otherwise he would have been lawyer. I would not even given
yes,
audience to him.
yes, my lord.
Whatever he is arguing.
Yes.
Because these are cannot be a subject matter of posting an FIR.
Yes, my lord.
You have your 161 statement, your case diary.
Yes.
We'll go through it.
Yes.
And we'll decide.
Yes.
Let us see for
My lord, then Jalukbari PS case number, my lord, 341/23, that needs to be my lord. followed.
Okay.
I will please fix a short date.
Mr. Bortha
341.
shall produce
341/20.
the case diary of Jalukbari PS case number
341/23.
341/23 on the next 6 weeks in advance of the aforesaid case diary.
Well, I may be directed to produce the case diary without fail, my lord, under the
uh,
341/20.
Case diary in advance the said case diary is necessary for proper adjudication of the present case. Full stop. Please this matter on
On 13/9, my lord.
13/9/2023. The IO shall invariably produce the case diary of the aforesaid case. Otherwise, he will, if aforesaid case, otherwise this court may consider action against the IO on the next date fixed if no such case diary. FIR cannot be caused like this, Mr.
My lord,
You study
there are
yourself,
7
since you are
days,
not-
7 days. Why the case diary has not been produced?
By earlier, my lord,
That is
no
the concern.
information sent to the Jalukbari
I
police
understand, I
station.
understand.
Yes.
Your case is not the only case that has
Yes.
been taken. Yeah.
Thank you.
Third, Mr. P. K. Dekka, Learned Counsel for the petitioner. The present application is filed for substitution of legal years of the respondent number 2 in the connected criminal revision petition number 12 of 2020. 12 of 2020. The background fact of filing such application are as follows. The respondent number 2, is that it?
Yes,
In criminal revision petition.
Yes.
Respondent number 2 in the connected criminal revision petition number 2 initiated a prosecution under section 138 of Negotiable Instrument Act here against the present against the petitioner in the connected criminal revision petition. The learned CGM Kasar Silchar aforesaid case was registered as NI case number 78/2010. The learned CGM Kasar Silchar by its judgment dated 20/11/2018 convicted the revision petitioner under section 138 of the NI Act and sentenced him to pay a sum of rupees 6 lakhs as fine with interest. Being aggrieved by the aforesaid judgment of the learned CGM, the revisioner petitioner preferred an appeal before the learned session judge Kachar Silchar, which was also dismissed by the learned session judge by judgment and order dated 18/11/2009. 18/11/2009. Being aggrieved against the present application, if being aggrieved, the connected revision petition being was preferred. During the pendency of the revision petition, the complainant, respondent number 2, complainant of the negotiable instrument case, plus the respondent number 2 in the revision petition expired. Accordingly, the present IA criminal IA has been filed as discussed hereinabove for substitution of the legal years of the deceased complainant respondent. Full stop. Do you have any argument or in terms of this judgment and
No,
My lord, only one or two add, my lord. Lordship, in default, my lord, 6 months rigorous imprisonment.
in default, if he will write it.
Okay.
The present petitioner, the complainant, respondent number 2, the criminal revision petition expired unmarried,
Yes.
leaving behind the present applicant as his class 2 legal year. The present present applicants are the brothers and sisters of the deceased. The law is by now well settled that on the date of a complainant during proceeding of a complaint case, the right of the legal year of the deceased complainant to continue with the prosecution survive. Such principle was laid down by the Honorable Apex Court in the case of San Devi Daga and others versus Mansuke Humatani and others, reported in 2018 1 SCC case 71. This court also considered a similar situation in the case of Kushal Kumar Talukdar versus San Prasad Goenka, reported in 2004 3 GLP 365, held that dealing with a complaint case under section 138 and 142 of the Negotiable Instrument Act, held that on the date of the complainant, his substitution of his legal year is permissible. Full stop. In view of the aforesaid proposition of law, in the considered opinion of this court, the present applicant should be arrayed as respondent numbers
2A to 2F.
2A to 2F, 2A to 2F, as described at paragraph
Dot.
Huh?
Paragraph 6 of
paragraph 6 of the interlocutory application. Full stop. Okay. Accordingly, the I stands disposed of. The I stands disposed of the registry to correct the cost item. Accordingly,
My lord,
I stands.
only one thing I want to just clear from my mind, my lord. Since my learned senior the doctor has said and 2 WA, my lord,
what it is exactly, my lord. If in future, suppose in this come, whether we will file application under 302 or 2WA, my lord.
See,
If this is clarified, lordship, so in future.
302 is something different. That's why we have not mentioned anything. In appropriate case, we will decide.
If you also mentioned here, my lord, so that in future it will
Let
help
us
us, my
see,
lord.
in appropriate case, we will decide. Because see, we are shortage of time.
Absolutely, my lord. Otherwise,
Ah.
my lord, your lordship does not have a landmark judgment. And so far in WA provision is concerned, my lord.
But for that, we cannot pass a
Then my
order
prayer, my lord,
like this way. We have concluded without going in this side or that side.
same situation
Then
will arise in
Then
picture
we
of
will have
second.
to interpret the moment it comes.
Yes.
We'll decide not to not.
Oblige, my lord. Oblige, my lord.
We would have liked it, but problem is that we are not having those luxuries nowadays to hear
Yes,
for
absolutely.
hours.
Yes,
No,
understand. Yes, absolutely, my lord.
people are waiting in the
Yes, yes,
queue.
yes, yes, sir.
Of
You are
course,
not wrong here. Oblige.
Yes. You know?
My lord, with your lordship, my lord, this appeal, criminal is directed against the judgment and order dated 26/11/2008, passed by the Planet Special Judge Golagat, whereby the appellant is convicted for 1 year simple imprisonment in a fine of ₹1,000. The appellant was convicted under section 13(1)(e) of the Prevention of Corruption Act.
Where is the affair? Read the affair.
My lord. Yes, my lord. Before going into the this, my lord, evidence part, my lord. First, I want to bring to your lordship notice the section 17 of the Prevention of Corruption Act, ma'am.
Yes.
Section 17, who are authorized to carry out investigation. Section 17. Section 17 is my lord, persons authorized to investigate. May I read, my lord?
Yes.
My lord, notwithstanding anything contained in the Code of Criminal Procedure 1973, no police officer below the rank. Here A is, my lord, in the case of Delhi special rules established, and this is not required, my lord. D is also not required. C, my lord. Elsewhere, of a deputy superintendent of police or a police officer of equivalent rank. Any offense under this act, my lord, can be investigated either by DSP, my lord, deputy superintendent of police or equivalent rank, not below that. But in this case, my lord, the investigation was carried out by an inspector of police.
But FIR is registered by the SP himself. How do you say that it was done by the?
The FIR was lodged by one inspector of police.
But it was registered by the inspector of police is the informant. But it was registered by the superintendent of police.
But investigation was forwarded to one Abdul Matin Lakhar, who was the inspector. He himself admitted during his, my lord, deposition.
Okay, Abdul Motin.
Yes.
This is your ground.
This is my first ground.
Yes, second ground.
And second ground is section, my lord.
First ground is section 7, violation of
No authority to investigate the
violation of section
17.
17 of PCA.
17 C, my lord.
17 A violation. Then
Next is the proviso to section 17, my lord. Second proviso.
second proviso to
With section 17.
section 7.
It says that provided further that an offense referred to in clause C. Section 17, my lord.
Yes.
Second proviso. provided further that an offence referred to in clause E of subsection 1 of the section 13. In this section, he was convicted, my lord. Shall not be
Just give me a minute. Yes.
This proviso says, my lord, that the investigation cannot be carried out without a written order from the superintendent of police. But in this case, no such authority was given to this inspector, my lord, who has carried out the investigation. It is so this entire investigation is defeated, my lord.
Then
That is my second point, my lord. Now next is, my lord, section 19.
Yes.
Section 19B, my lord. And section 19 says no court shall take cognizance of an offence punishable under section 7, 10, 11, 13, and 15 alleged to have been committed by a public servant, except with the previous section, my lord, D is applicable here. In the case of a person who is employed in connection with the affairs of his state and is not removable from his office, save by or with the sanction of the state government or that government. My lord, this
D.
D, my
Huh?
B, 19 B, 19
1B.
1B. This appellant, my lord, he was a ranger in the forest department under the state of government of Assam. So, in order to prosecute this appellant, a sanction was required from the government, but no sanction is given in this.
Yes. Then
my lord, I'm coming to the very FIR. Allegation is that, my lord, this appellant was found with a disproportionate assets amounting to rupees 8,36,985, which was not known to his known source of income. This FIR was lodged on the basis of a RA, regular inquiry, conducted by the Vigilance and Anti-Corruption. Whereas there is no date in this FIR.
FIR is 18/12/2000.
No, that is not mentioned here in the FIR, my lord. Yet also admitted during his deposition.
FIR start at page 13.
That is,
Is not it? First information report.
yes, ma'am.
That report says a date 18/12/2003, but more you are.
It was registered on, my lord, 18/12/2003, my lord. It was registered by the concerned police
There is a
station.
date in the FIR.
But
So they have received this first information report 18/12/2003.
but this
On the basis of what?
Written
Written that may
Written
not
complaint.
contain a date, but it was received on 18/12/2013. First information.
It was received on 18/12 and accordingly it was registered. But the FIR
Will that not giving the date in FIR be so fatal?
yes, ma'am. Because this FIR, even if we assume that this FIR was lodged on 18/12/2003, my lord, prior to that, and regular inquiry was
Inquiry is conducted.
yes, ma'am. Regular inquiry was conducted. That was completed in the year 2001, ma'am.
Yes.
That was completed in the year 2001, my lord. So, when the RE was completed in 2001, why the delay of 2 years in registering the FI?
Yes.
No, my lord, the prosecution side had examined three PWs, my lord.
Hmm.
Prosecution witnesses, my lord. The PW one was one Ganeshwar Manto. He was, my lord, just a custodian of documents.
PW.
One. He was just a custodian of documents. So, my lord, his deposition is not so important.
Now, what you say, Mr. Public Prosecutor? EC Act no sanction, number one. Number two is that investigation is done by a sub-inspector, not by deputy.
One minute, I have.
Thus, his first argument is under section 17. It's very specific that no investigation by an officer below the rank of deputy superintendent of police.
Yes.
Here, FIR was registered by superintendent of police, but admittedly investigation was conducted by an SI.
Inspector.
Inspector. Now, another aspect of the matter is so his first case is that 17C.
17.
Section 17C. Notwithstanding anything contrary in the Code of Criminal Procedure, no police officer below the rank of, in case of DPS, that is not applicable. In case of metropolitan of Bombay, Calcutta, Madras, Allahabad, different, and elsewhere.
Yes.
Have you got it?
Yes.
Elsewhere. Of a deputy superintendent of police or a police officer of equivalent rank. This is one. Second is shall investigate any offense.
Then provided.
Now proviso.
Here
First
it is
proviso.
permitted.
Not second, first proviso. Provided that if a police officer not to the rank of inspector is authorized by the state government in this behalf by general or special order, he may also investigate any such offense without the order of metropolitan magistrate or magistrate of the first class, as the case may be, or make arrest thereof without warrant. Now
That means hereby, the power of the DSP has been delegated to
the
inspector.
inspector. So there must be specific order in that
Yes.
effect. And it will be the prosecution's responsibility to show that though I was authorized under the there must be something. So we'll have to look at his chief.
Yes.
His examination is chief. That answer can be granted first proviso. He is coming to the second proviso. Provided further that an offense referred to under clause B of subsection 1 of section 13 shall not be investigated without the order of a police officer not below the rank of superintendent of police.
Hmm.
That also may be in the case diary. It will not be a part of, suppose, what was the offense alleged?
Now,
13?
if there is any general notification that under section 17, inspector of police are also authorized to, then it will.
Then there will be
no problem.
There no problem, because we can, court can also take judicial notice of
Yes,
that,
yes,
even if no
yes.
question is asked.
Public document.
But
my lord,
if nothing is there,
Hmm.
then it will vitiate the entire procedure.
that is.
So before going to the all other evidence and entering the merit, I think we should answer these two questions first. What you say?
Yes.
Isn't it?
That
Unnecessary.
has to be examined first.
That first is to be attended. Where is the evidence of IO?
PW.
PW?
I have tagmark, my lord, in that.
Okay. Let us see what he said.
IO, my lord.
Yes. So according to him, he was entrusted by SP to investigate case numbers 20 PCA against the accused Muhammad Said.
Then proviso is completed, my lord.
Proviso is complete.
You will have to produce that related document, my lord.
We'll see what
No.
cross-examination have you done. Let us
Cross examination, that will depend on cross examination, whether to that
Ah,
extent.
that will
On
depend
that point,
upon
he has
the-
cross examined or.
If you doubt these questions, no, you have not been entrusted, then only other question will. Therefore, we first let us read this. Forget about other things. Read the. You have not questioned his authority. You have not questioned his authority.
But my lord, proviso said that no officer below the rank of a DSP can investigate the matter. But here he says that I was entrusted. The SP cannot entrust, my lord.
No, that is the proviso.
Proviso.
Second proviso.
Second
You see the second
But
proviso.
where is the notification? There is no
No,
notification.
no, he has said you have
You have not
crossed,
controverted it, you have not
confronted
challenged
that.
it.
No, there was no notification, there is no suggestion at all. But there are some difficulties. Look at the cross examination. His wife was a teacher. House was in the name of his wife.
Yes.
He has not examined wife's income. He has not taken other house rent from the house.
No agricultural income was also included.
How then whole procedure?
Normally these are matter of reversal evidence. He has to show
but-
that these are from his known source of income.
No, understand.
When
Understand. When you calculate his house, everything was collected and inventory is made. But he submits that this belongs to his wife. She was a government servant and house was constructed by taking loan from LIC.
that is why what I submit. When such prima facie allegations are there, he has to rebut it. No, so this is
No,
my
prima
these are my
Foundational fact you will have to lay.
Yes.
You will have to rebut.
Yes.
Foundational fact you will have to, like NDPS.
Right.
You will have to lay the foundational fact.
Mm.
What is the foundational fact? Let us see the FIR first. Disproportionate assets to the tune of 8,36,985. Okay. How this 8,36,985 has come in terms of exhibit? Huh?
Exhibit 3 evaluation,
Where is that?
Exhibit 3.
exhibit in another file, in the LCR.
No, no, that is exhibit 3. This is exhibit 2.
Statement of
Statement of evaluation.
calculation of statement. Exhibit
Who is the statement of whom? Mujibuddin.
Is the
Huh?
This is the document. This is the document.
Exhibit 2 is the statement.
Calculation statement of asset of Mohammad Mujibuddin. That is
House or shop, other building. Sayyid Mofiza Hussain. Sayyida Mofiza Hussain. Date of acquisition 28/7/1979.
amount is no doubt meager amount
By
for such a long
bigger
period.
amount as
For
on
such a
date.
long period.
But that time we will not go by the amount. Kindly see first house and shop or other building. Sayyida Mustafa Hussain, date of acquisition 28/7/1979. Might be her father's property. By purchase, okay, 1976 purchase. Land plot in her name, other type of immovable property nil. Now, price paid for property of if acquired otherwise than by purchase mortgage to 2,000 rupees. He purchased the land. Source of income service.
one thing, my lord.
Now, details of property disposed of. Nil, all nil. He is having no property. Any means of convenience, car, scooter, motorcycle, nil. Ornament, jewelry, no comment. Price paid for acquired trees, nothing.
Period is also very long, like from 68 to 99, 31.
No, that is what I said, keeping in view the period of occurrence,
No,
Yeah.
we assume that
Yes.
your documents is true, but there
Yes.
is no restoration is taken out. Foundational fact is not there. Furniture, old model sofa set, 1,000 rupees. Old model carpet, 500. Radio, unserviceable, 400. TV, old model, Beltec, 4,000. Tape recorder, one Olin refrigerator, one Contron dish mixie, 3 rich watches, 600 rupees. 2 Hawkins cooker, statement 4. Now, where is the final calculation?
Exhibit 3 is the final calculation, my lord.
Is there?
No, my lord.
Hmm? Nil, all nil. Income statement. Rent, first floor house rent, first floor house rent. Income from pay and allowances. Listen to this, Mr. Das.
My lord.
Income from pay and allowances. So, what is this proportional? This is your income and this is your asset. So it's disproportionate. You will have to explain. It's he who will have to explain. Now let us see how you have laid the plan. Income from pay and allowances, yearly breakup to be shown. I am unable to collect pay allowances because of him served at Silchar, Guwahati, Goalpara, Dolong, Dorong, Dudhnoi, Damdama, Dibrugarh, and Hamren. He's because so many years I cannot go and investigate. Income from sale of property, no. LIC bank account, NSC, no. Any other source of income with details. Agricultural income for cultivation of paddy during 1991, 9,500. Cultivation income since 1980 till date. Emily maintenance cost analysis. Okay. Let's go through it. What is the law? They have taken the house to be and the building to be taught. Therefore, return. The PWD engineer was examined.
Yes, madam, PW5.
PW5.
PW5. But where is the assessment of the building was done at rupees 11,84,937. The building was constructed way back in the
1979.
79 to 83, between that. But the value was assessed at the rate of 96.90.
So that
That is admitted, sir.
go through it. Check anything which say it will be far-reaching consequences for many others. You go to
Sanction থাকিলেও নহ'ব, exhibit কৰিব লাগে sanction টো।
Exhibit to
If there is sanction at all, that has to be exhibited. no?
sanction is- fixed extension is method.
Otherwise, you know, by the time charge sheet was submitted, he retired. So, you know, 197 sanction is not required. But in PCR, the language is different.
Even
Is or was, you know,
Or is
if
or
he
was.
was, you know, past tense. Their difficulty is
there,
there. you know.
here it will be necessary. And PCA is specific.
So,
We will take it up tomorrow or day after.
tomorrow is Thursday. Thursday, let it be Thursday.
Tomorrow,
Let it be Thursday.
Too many matters to take. Let us take it on Friday.
Let it be Thursday.
Just go to it and mark it and just enlighten us. Just looking at this issue, yes, of course. Wife, suppose wife is not working anything. Properties are in the name of wife. Wife can also be, I think, dragged into.
Yes, yes, contribute. you know.
No problem. But here, admittedly, the property was, land was purchased at the rupees of 2,000. It is the prosecution case in the year 79, 2,000 rupees. And 50,000 rupees was taken loan from LIC to, this is your report, for construction of the house. Now, will it be taken the value on a subsequent date?
apparently house ten was.
I purchased a flat at the rate of 12 lakh to Janvata. Now it may be fraud. 2 days bill. So that effect, how we'll have to deal with. Please go to it. Friday. Hard at some length. It's better. Friday.
Record to here, let
Huh?
record. Let the record be here.
No,
Tomorrow,
I am keeping the record. You
Tomorrow-
just have it from my chamber and give it. to
Yes.
We'll bring it by sleep. Okay, then it's easy. He'll go through it, his record. Will Friday by sleep or what? You
Yes, yes,
will
yes.
not send the file till
Mm.
Thursday.
Fine.
We'll send it Thursday. Tomorrow is
by
Wednesday.
tomorrow or day after, I will.
You
give you
go
also
through
in
it,
the
then we'll send. Okay. Let me also go through.
Man. In maximum, you know, say section 13 conviction, in maximum cases, I have faced such type of problem. you know. Property was purchased in way back in before 50 years,
Yeah.
and you know, valued the
Ah,
present valuation is
Of
done.
course.
Right.
My plot at Borpeta, that cost us around 500. It was 500 rupees, 1 bigha of land. And what are the other methods? Any urgency? Old or new?
2070 হয়ে গেল নাকি?
Yes, Mahmood.
My lord.
What was this? Why you did not adjourn? Some payment.
Yes, Lordship, in this council, Mr. A.W. Aman was out of station, so that's what I mentioned this matter for adjournment, Your Lordship.
You want to have some whether payment.
I have no objection. I leave it.
No, no, you'll have no objection. You have an problem is this it is maintenance, is not it?
Yes, Lordship.
Money has been paid. Last day I have given.
He disputed that. That is what we sought an instruction.
Yes, Lordship. Some NJ Khatun are supposed to appear before this.
So that there was a proposal that it goes. You are saying that I am regularly paying. He is not saying not railway. Why should we?
Almost regularly paying.
Ah.
And some, there is a order
Okay,
that
on the prayer of the learned council for the petitioner, the matter stands adjourned and be listed after 3.
no, not petition.
So respondent.
Deeply available.
Lordship, may kindly take up this matter on another topic.
Criminal appeal.
Lord.
You are on bail.
Lord.
Please this matter in the part 2 hearing.
Lord, I am appearing for respondent number 2, Lordship.
What is this? What is the conviction?
10 years, Your Lordship. 10 years, Your Lordship. 10,000, Your Lordship, and in the fourth format. One of the fourth.
You have been granted bail.
Lord. Granted bail, Your Lordship, by order dated 21/6/23.
Yes. You have what?
Lordship, I am for respondent number 2, Lordship.
We'll hear you.
I have filed the other side, Lordship, government have filed objection also, Lordship.
No,
So
he has
I
already
only
granted
just,
bail.
I only just assist.
You will assist him already granted bail.
Yes, Lord.
Let us fix it in the part
Lo-
2 hearing list.
Part 2 hearing list, Lord. Okay.
Part 2 hearing. Let the others, he
Lost-
also be,
Lordship.
let him stand in the queue.
Lordship. Lordship.
If it no, had not been granted bail, you would have list this matter in the part 2
Item
hearing.
58.
Obliged.
Devolver.
What is this?
My lord, in this case also, Lordship, punishment was for 10 years, but 8 years, 17 days already passed. And for the fine period, he is inside the jail, Lord. Because of that reason, we discussed with the trigger, Lordship.
So according to you, you have
Yeah,
sentence is over.
yeah, because from the date of arrest, he is inside the jail.
Hmm.
So, Lordship, 4/8/2015,
Just
he was
that
arrested.
narcotics, what do you call it? NCB.
NCB,
NCB.
Narcotic
When
Control
arrested on when?
4/8/2015, Lordship.
4/8/2015.
15, Lordship.
And punishment,
Punishment was for 10 years, Lord.
so then it will be 25. 10 plus 15 plus 10.
Yes.
10 years will be on
Will-
already over.
No. Lordship, 4/8/2015, if we calculated,
There will be
then from the date of arrest, it will be
he was
counted
arrested on which date? 4/8/2015.
4/8/2015,
And what is the punishment?
10 years.
So if it is 10 years, still he is in jail.
Yes.
So his 10 years will be over in the year 2025.
25. No. Lordship, it will be run concurrently. Then,
But 10 years.
10 years, Lordship. 8 years, 17 days. Lordship.
Till now it is 8 years, 17 days.
Yes.
Now 2 and some year remain.
It remains the part that is for the leave and all in as per jail menu. Then some remissions are there to that figure.
So where do we get that?
In 10 years, not that it is 1.5 years.
So let us have a. We cannot say that no, it's over. We'll have to give a reason.
No, we are not saying that. For that, because under NDPS Act, punishment along with the fine and lordship. That is why lordship cannot reduce this sentence.
Okay, we will not reduce this.
Yes, lordship must have to hear the matter and lordship pass the judgment as per this lordship.
Or suppose there is no remission or what?
Remission is there, lordship. Remission is there. As per jail manual, lordship, leave and the holidays of calculating this.
What is your ground in challenging?
The grounds are, lordship.
Are you ready?
Yes, I'm ready.
No, not today, Your Lordship. because
17,
my-
2017.
Then Your Lordship.
Looking at your face, I could understand that you are not ready.
That is why, lordship, last occasion also it was
What is your ground?
my ground in this case, lordship, six witnesses examined by the prosecutor. But in this case, the 52A and the 50 is not complied here in this case. And one independent witness is also examined by the trial court. That is not supported there. He is not supported this case, lordship, because he has stated that Muhammad Hassan, he mentioned the name, but at the dog, he could not identify the person. And he called by RPF. RPF person are not the witnesses in this case. For a moment, lordship may go through the
Was these are the important.
yes.
Lordship, if my learned friend completes today, we will
It
give-
is also difficult. We are in the midst of so many methods. Again, I will forget everything.
yes.
No, because of this urgent, lordship, several
Urgency is there. A person,
yes, I know,
suppose it will be a blame on us.
Yes.
Suppose we acquit.
Yes,
If we convict, there is no problem on that.
Yes, yes. May I pray Lordship day after tomorrow?
You can pray, but difficult to allow the prayer. Every day I am rising at between 3 and 3:30. I think yesterday around 2:15.
my lord,
Which witness you want?
witness lordship, PW, no, 6, no, 8, seizing officer,
Record.
seizing officer too.
We will also become slowly casual. Seems Mr. Das.
PW,
Yeah, what happens will happen like that. It should be slowly come. Because
PW3 is the seizing officer, lordship.
what is the affair?
In this case, FIR is not there, lordship.
Otherwise, you also cannot appear in this case.
Yes, Your Lordship.
You cannot appear. You are not a file is a what?
Yeah, yeah, yeah.
File is
On his behalf.
PP. It is a PP, special PP for
Special PP for
NCB.
NCB.
How can she represent?
That's the
Where is
main.
Kyle?
On election code number 17.
Kyle is too busy. You should engage somebody. Otherwise, we'll engage the Amita for
Lordship, PW3 is Suresh Kumar Singh. He is the seizing officer in.
your name is accused is
Accused Muhammad Hassan.
what is this?
Handwriting as so.
No. Why this is different? This is a rape case. This is criminal appeal 168 of
No.
2022.
193. Criminal appeal 193.
What is it? keep it, ask them to put in a proper. First verify whether this matter is fit.
My lord, lordship, if you want to see the exhibited document, then only lordship, you can come to the WT lordship.
Where are the evidence? You have an
Evidence is there, lordship.
that is there and
In the record, lordship, PWT handwriting is so difficult to read, lordship. Exhibit. Exhibit 4 is the NCB 1, on the basis of which lordship, the information reduced into writing. Thereafter, they proceeded to the railway station, Guwahati railway station, lordship. There they waited for the train, and then they entered in the general compartment, and from the general compartment, this person was apprehended and boarded down to the platform number 5. Then they took the person to platform number 1. So in there was no any independent witness from that platform number 5.
place of recovery
No.
to the
Platform number 1, there is no witness, lordship, from platform number 1 and platform number 5. One person, PW6, he is deposed that he came to board in the train, and then what happened, lordship, RPF personnel requested him to be present at the time of this search and seizure. Accordingly, he present, some contraband recovered and put signature in the seizure list. This is his deposition before the court, lordship. He is the person, and he is not the local person. Yeah. Lordship coordinate bench has passed the judgment to that regard. Under NDPS case, lordship, independent witnesses from that locality is required, lordship. So that is, these two persons name mentioned in their final complaint, they were not before the court, lordship, and they are not the local person of that locality, lordship. One from Nalbari, one from Rangya, lordship. Exhibit 4 is the information reduced into writing, lordship.
where is the FIR?
In these cases, lordship,
No
normally
FIR, but the
NCB 1, NCB 1, exhibit 4, lordship.
exhibit
Lordship.
information of
Yes, it was reduced into writing, lordship.
the minute is there any indexing.
মই কিবা এটা ready করি, এখন তো translate করেছিল।
Exhibit 1.
Yeah.
1.5 kgs of heroin.
Here it is mentioned heroin, but subsequently, though they have mentioned that heroin, but FSL report stated that are morphine, lord.
That is the petition.
That is the information, lord.
Where do we get that? This exhibit 3, isn't it?
4. Exhibit 4.
Exhibit 4, information of offense. Where do we get that? No indexing, nothing of that.
Exhibit 4, lordship.
Exhibit?
Exhibit 4, lord.
Yes.
Lordship. Today, my casual informer informed me that one person, namely Muhammad Hassan, is carrying a consignment of heroin in the backpack, and he is traveling in general compartment third coach from the engine in Abu Assam Express. He further requested me to
Catch the person.
catch the person and give him the suitable reward. Then this was forwarded to the superior officer. Next document of thereafter, office order, exhibit 5, office order was prepared. They have stated that on the basis of this, the office order was prepared and constitute a team to move to the place of intersection. Then lordship, they rush to the place of occurrence, and then seizure list exhibit 8.
Yes.
Exhibit 8 is the seizure list. Panchnaama also annex with
Exhibit.
8.
These are Xerox copies or what? Was this exhibited?
Is it Xerox copy? Can I see that?
There is no marking of exhibit.
Record.
Seen, only seen. NCB 1 seen, Chief Judicial Magistrate.
Exhibit 8.
There is no marking. This is NCB 1.
Yes.
Star Switch and Narcotics Control Bureau, Guwahati Zonal Unit, Guwahati 7 Reference. Code number of informer, casual.
Yes, yes. That one is-
Community conditions.
Yes.
These are Xerox copies.
Lordship, kindly give me the recorder to check, just to check. Xerox is oval or
And there is no marking of exhibit.
During the trial, Lordship, the defense lawyer should object this.
Whether
case.
defense lawyer raise objection,
Uh,
my lord. If no objection
Objection
is
must
raised,
have to raise during that period. if there
but
are-
yes, the signatures cannot
See,
be.
this is a table of contents, exhibit 1 to 70. Is suppose exhibit 3. Exhibit 3 is written in
Exhibit 3 is Lordship, is final complaint.
final complaint.
Yes.
Exhibit 3 is marked as exhibit 3 NDPS 2016 47 2016.
Yes.
Check Siresta's signature is
Oh,
intelligence officer.
That means it is compared. with the
Huh?
original.
No.
This is
Xerox
original.
one.
This is original. Red pen.
Oh.
Okay. These are
Yep.
red pens. Exhibit 3-2, the seal. Okay. All these are original. Exhibit 3-4, the seal of the intelligence officer. Now, after that, exhibit 3, exhibit 3-8, signature of intelligence officer Pawan
Baisane.
Baisane.
Yes.
Then come, there is like,
এখন কি document, because
And NCB 1 what? NCB 1.
this is a recovery of seizure from NCB crime case number.
Yes, this is the first document of their department, Lord.
This is the first document.
Yes.
So this is marked as exhibit 3. And the index starts exhibit 1. So index starts with exhibit 3 to exhibit 3-8. I have shown you all these signatures are marked as exhibit 3-1, 3-2, 3-3 like that. Then page 15, annexer A to Z
And next one, 8 to 3.
of that complaint.
Oh,
No
Oh.
separately exhibited. Do you get my point?
yes.
They annex all these Xerox copies.
and
And
that,
those-
that from exhibits have been.
These
Those
other documents annexer A to Z, these seizure and all, were made part of the exhibit 3. Exhibit 3 is exhibited, but not these documents. All those are Xerox copies.
Then we have to look.
How
in-
can on Xerox copies? Court
Be
can-
exhibited
Sometime
during
what
the
happens?
trial.
Sometimes what happens in court, original documents are given to the court for comparing the photocopies.
No, but
and
you see this. It is
there-
not like
after It
that.
has to be seen, whether original.
Now, because 9 to 23 pages are not indexed as exhibit. It is indexed as exhibit A, annexer A to Z. You get my repetition is
yes.
exhibited.
It is annexure.
Yes.
It is the annexer.
At the time of filing the final complaint, they annex these documents.
Hmm.
Then,
Now, here are some exhibits. Let us go to that.
Lordship got the
Page
exhibit
24. Let us go to the page 24.
is 24. Exhibit 8. Or okay.
Exhibit straight away. Next exhibit is exhibit 20.
Exhibit
First
20.
exhibit 3. Then straight away exhibit 20. Exhibit 20 is in original, that is
Intimation
intimation of
of
arrest.
arrest.
Okay.
Yes.
Then thereafter it will go to annexer 1 to K. 1 to K are all Xerox copies. Go down, receive, this, that, everything, all Xerox. Now it comes to exhibit 19. 19 is the packet, wooden box, bottle. This is received by the
FS.
forensic.
Yes.
Where is the seizure list?
Seizure list is exhibit A.
Where is exhibit? There is no exhibit A.
But as per deposition, we got it, Lordship.
Annexer A.
Yes.
How can that be?
Can I see, Lordship?
Of course. This is NCB. We think them to be the one of the finest of the investigating agencies. Seizure list, nothing is exhibited. All Xerox copies. Even not marked. Or forget about proof. Go to this. These are exhibit files. And a person is inside for 8 years. Who will compensate? No, Mojib right? Okay, give that, give it. You see the index part.
Yes. Annexes.
What
Then
index are?
exhibit 20 to 21 annexes. Oh.
See, all are Xerox copies. How the seizure is proved?
My lord, this may be there. Original because it was not exhibited.
That's why not exhibit? Are you not getting? You see the exhibit 3 first. Exhibit 3. First you see. Is it not exhibited? Now go to exhibit 19. 20, exhibit 20. See the page number. Is it not original?
Yes.
Then go to exhibit 19. Original.
17 also there. Then 18. 22.
These documents, seizure list and all, are not even exhibited. Forget about printing original.
No.
This is the list of documents. See, first.
Yes. But Lordship, I think other documents may be in that file also.
The next file is file A. File A are the deposition.
Only the deposit.
Now I'll say what are the appendix, judgment, what is written in the judgment. Exhibit 1, forwarding letter of FSL to accused. Exhibit 2, FSL result intimation to final report. Exhibit 3.
Yes.
Exhibit 4, information of offense.
Yes, that may be there, Lordship.
Thing is there. Go to it.
I thought.
Nothing is there. What the file name is? Huh? What is this? This is the official, our High Court report. Go to it.
Yes. Oh, these are.
We say, we say mayor marking will not do. It must, mayor exhibiting will not do. It should be proved, content should be proved. Forget about the content, not even exhibited.
Very strange, Lordship. Normally, NCB never commits such type of mistakes. Exhibit 4 exhibited here,
What was exhibit?
NCB 1.
Okay. So, in which file? Who exhibit? Okay, exhibit 4. Then
And exhibit 8, I think maybe there, Lordship. Exhibit 8, along with other, exhibit 8 is the scissor lister.
what is the name of the accused?
Mohammed Hassan.
It's a here, but it's still different.
Lordship, exhibit 8, Lordship, I think got it.
Exhibit
8.
A, 8.
Yes, with exhibit 8, one customer is there, that is why I'm. asking.
Okay, brown color powdery substitute, plastic packet.
This is
So
the
the-
scissor, this is the scissor list, Lordship, along with this one handwritten document is also there, Lordship. Some pages.
After getting.
Yes, yes, this is the, they stated that this is the customer. For a moment, if we go through this, Lordship, and the case will come out. May I read this, Lordship?
Yes.
After getting information from a reliable source on 4/8/2015 at 19 hours that one person, namely Mohammed Hassan, will be carrying a consignment of suspected heroin and he will be arriving from Dimapur to Guwahati by Awadh Assam Express on 4/8/2015 at about 22 hours. And after reducing the same information into writing, it was intimated to Mrs. Tulika Morang, Superintendent NCB Guwahati. Thereafter, a team consisting of Mrs. Tulika Morang, Superintendent Sri Sanjay Singh, Sri S.K. Singh, Sri Santu Saha, Sri Pawan Raskin Talukdar, and P. Vishwajit Singh. Other officers' name are there, Lordship. And then after getting proper movement order, the said team started from NCB office, Guwahati, at about 19:30 hours on 4/8/2015 and reached at Guwahati railway station at about 20:10 hours. After reaching at the Guwahati railway station, NCB team requested two persons, namely Sri Biren Das, son of Rajat Chandra Das, village Amayapur, post office Basel Road Shop.
So Biren and Ripon were witnesses.
Witnesses, they are from one from Nalbari and one for Gandhi Basti here, Lordship.
Now
But
where are
this person, Ripon Suikia never
examine?
examine.
Now what about this Biren Das?
Biren Das examine as PW6.
What is his statement?
His statement in deposition as PW6, Lordship will get original today.
PW, where do I get which file?
It is in deposition file, Lordship. PW6, Lord.
Just a minute. With the other file.
That's not deposition of file.
Okay, deposition, no?
Yes, it's PW6, Lord.
Just a second. PW6.
Yes. মই চমন পাই সাক্ষী দিব আহিছো যোৱা 2015 চনত এদিন মই গুৱাহাটী ৰেলৱে ষ্টেচনৰ পৰা ৰঙিয়া যাব আহিছিলো তেতিয়া RPF লোকে মোক নমাই প্লেটফৰ্মৰ পিনে নিয়ে এটা কলা বেগ আছিলে বেগটো খুলি এটা সৰু পেকেট পায় তাত কিবা পাউডাৰ জাতীয় বস্তু আছিল তাৰ পাছত মোৰ সহি লয় পাউডাৰ কিনি 1.5-2 কেজি ওজন আছিলে পাউডাৰ পোৱা লোকজনৰ নাম মোহাম্মদ হাসান হয় আজি দেখা আসামী জনক ভালকৈ ধৰিব পৰা নাই Exhibit 8 জব্দনামা হয় then signature exhibited তাৰ উপৰিও লোকজনৰ বেগৰ পৰা ATM কাগজ পাই জব্দ কৰে metal exhibit seal envelope ID card DL ATM railway ticket কলা wallet হয় মোৰ সহি exhibited documents are there lordship then the cross মই টিকেটখন জমা কৰা নাই মই আৰ্মি এক্স সাৰ্ভিসমেনৰ ID জমা কৰা নাই RPFৰ লোকে মোক প্লেটফৰ্ম নাম্বাৰ 1ত নিয়ে মই
Just a minute, just a minute. Anything here said where the material was seized?
No. No, Lord. Yes, only stated that he was taken
Nomai platform or pinia near.
platform opinion.
Nomai means he was inside the train.
In which train that is
Nothing.
nothing. And RPF officials, Lordship, 1 to 5, they are the NCB officials, Lordship. Except PW4. PW4 is the FSL expert. And in cross, he has stated, moi Assamik nisinisilu. Order kini ki powder nezanu.
Yes, so you want to say Caesar is not true?
No.
That's your case?
Yes.
Anything else? Anything?
And if suppose Lordship Caesar made, in that case Lordship 52A regarding sampling and all, letter judgment is also there, Lordship, and your Lordship judgment is from division bench, Lordship, we get that. So in that case, Lordship, regarding 52A, Lordship, after search and seizure, they must have to, if they collect samples earlier, they collected this type of samples at the place of occurrence. But there is a judgment of 2016. Then Lordship, they have to bring all the contrabands along with the accused to the in front of the magistrate, and in front of the magistrate they must have to.
Now, how is your Caesar is this only before this, and how this collected the sample? Any?
There is nothing. They on the spot they have collected all the things.
Who said that they have collected?
PWT.
PWT.
Arekkano para I have typed Lordship, but little bit correction is that because handwritings are not visible on here.
Okay,
For a moment, Lordship may
you have typed it.
little bit corrected is there, Lordship, I'll correct it. Married.
Hmm.
On 4/8/2015, I was posted as intelligence officer NCB Guwahati. On that day, my casual informer informed me that one person, namely Mohammed Hassan, is carrying a consignment of heroin in his backpack, and he was traveling in general compartment third coach from the engine in Abad Assam Express from Dimapur to Guwahati. After that, the information was reduced to writing by me and intimated to Mrs. Tulika Morang, Superintendent NCB Guwahati. After that, the site information was passed to Praveen Kumar, General Director, NCB Guwahati, and a team was constituted as per direction of Superintendent Officer NCB Guwahati. Then, Lordship, Exhibit 4 is the NCB 1. Tulika Morang and Praveen Kumar, General Director, NCB Guwahati, is known to me. After that, one office order was made to constitute a team to search and seizure comprising of Tulika Morang, Superintendent Sanjay Singh, IO, myself, Pawan Baisani, IO, and Raskin Taludan, six of sepoys. On the strength of the order, I was appointed as seizing and search officer of the case.
Who was the who identified that this is the Hassan?
No, there is nobody. That was not mentioned in any way because there is general coach, general compartment, lots of persons are there, and nobody from the among the general coach.
An identified suspected person with the help of informant. Who
Informant.
is informant?
That is not mentioned. And informant was-
Informant or informer? If it is informer, whether informer was examined.
No, that is not there. So, may I read?
Yes.
After that, the detailed team left Guwahati NCB from office at about 19:30 hours on 4/8/2015 and reached at Guwahati railway station at about 20:10 hours. After that, the said team reached at the platform number 5 of Guwahati railway station where Abad Assam Express was supposed to arrive. After that, I contacted two persons, namely Biren Das and Nipen Saikia, who were standing at platform number 5. When Biren Das stated that he was at platform number 1. So, being introduced ourselves to both persons and requested them to be independent witnesses, also sharing the information we had on which they voluntarily agreed. Accordingly, the Abad Assam Express from Dimapur reached Guwahati railway station at about 22:05 hours. After indication by our informer, I think, Lordship, because of writing it may be mistakes. NCB team alongside the two independent witnesses entered the general compartment third from the engine and identified suspected person with the help of the informer. The NCB team approached the suspected person and shared the information. On asking, he introduced himself as Mohammed Hassan. Since the coach was crowded and on security points, the NCB along with the suspected person with a bag which was carried by Mohammed Hassan with two independent persons got down from train and went to near RPF office at platform number 1 for any search and seizure. Then I issued a notice under section 50 of NDPS Act to Mohammed Hassan, wherein I intimated him that it is his legal right that his personal search may be conducted by before a magistrate or a gazetted officer, to which he refused to do so in writing. It is also one of the important point, Lordship. Nowadays, our apex for one full bench judgment passed by the Honorable Apex Court, that Lordship. Once section 50 they apply, if nothing recovered, in that case also requirements of the section 50 must have to comply by the investigating agency. So exhibit 6 is a notice issue under section 50 of NDPS Act. Then these are the exhibitors. The consent is made in presence of independent witnesses. After that, the personal search of Mohammed Hassan was carried on by me in presence of two independent witnesses during personal search of Mohammed Hassan, one voter ID card, one railway current ticket dated 4/8/15 from Dimapur to Baksa, one driving license issued by government of Nagaland, and few currency notes amounting to rupees 581 SBI ATM card was found. After that, his bag, which he carried, was opened in presence of two independent witnesses and other team member. On opening the bag, few garments were recovered, and at the bottom of the bag, one plastic packet wrapped with sellotapes was recovered. In presence of suspect and two independent witnesses, found the packet and brown color powder material recovered. Small amount of powder was tested with narcotic drug detection kit, which was carried by NCB team, and said powder material tested positive of morphine in our narcotic drug detection kit. After that, the plastic packet was wet, which came to 1.5 kg. After that, photographs was taken of the consignment. On the spot questioning, Mohammed Hassan confessed that it was morphine, and consignment of morphine was given by some Mohammed Saiful, resident of Golapati, Sapta, Imphal East at Dimapur, and further he was going to deliver the
What
same.
was exhibit 10?
Exhibit 10 is lordship. Statement of Mohammed Hassan. But nowadays, lordship, if a statement recorded 67, that is not in me.
Admissible. After my lord justice
Yes,
uh,
that is Tufan Singh.
Tufan.
So then Lordship Mohammed Hassan revealed that is regarding the statement. Mohammed Hassan revealed that he was involved in illegal trafficking of morphine for test many years for monetary benefit on the reasonable belief that an offense has been committed under Section 8C NDPS Act, punishable under 821C NDPS Act.
Okay, we'll do it some other day.
I prepared a note that properly can place this.
Yes, sir.
Can be this Friday or Monday.
Brain is exhausted.
Yes.
60 meters.
Yes, sir. We also agree that.
Give you note.
No. Can I place the citations?
Give it.
Hello. Yes. Citation.
I have written only. Matters are over.
Yes.